In view of the aforesaid discussions and the facts and circumstances, this court is of the opinion that no case for interference is made out and accordingly the writ petition is dismissed. It is however observed that in case the petitioner wishes, liberty is granted to the petitioner to file an appeal against the order so and so, in which case the appellate authority would consider and dispose of the appeal, which however has to be done strictly in accordance with law. Records are returned.
Much obliged.
There is a compilation you had given. You also take back. Otherwise, it will go waste.
Lordship, I take.
Records can you get, huh?
Much obliged. To mention item number 9. Lordship, due to certain medical exigency of my senior, he could not appear today.
Who is your senior?
Yes, Sinha.
Okay, 17 matter. Medical exigency will allow.
Only for the day. Only for the day.
We'll have it on Monday. Okay.
Highly objected.
On a request, a request has been made on behalf of Sri K. Sinha, Learned Counsel for the.
GL Bora. GL Bora.
On behalf of Mr.
Oh, yeah, yes. Sorry.
On behalf of Sri K. Sinha, Learned Counsel for the petitioner, who is stated to be, who has on medical grounds, considering that this matter is of 2017, while adjournment is granted, it is directed and the registry is directed to list this matter on Monday.
Wait, please, Your Lordship. I'd like to mention item number 5.
Yes.
The
Again, 17 matter.
Your Lordship. The A. Hussain is out of station and he informed that the client, after the demise of DR Gogoi, so he may change the counsel. So some time may be granted.
We'll grant you a week's time thereafter.
Oh, Lordship.
What is your name?
SRA Nasir, Lordship.
SI Nasir Learned Counsel has made a mention, has made a request for adjournment as the leading counsel, Sri DR Gogoi is no more. Full stop. Matter is adjourned by a week to enable the petitioner to make alternative arrangements.
Deeply opposed.
That places Your Lordship. Lordship, in item 10 and 12, we have circulated adjournment petition yesterday.
Yes.
We could not prepare the case, Your Lordship. So, item may be adjourned.
Who circulated?
We have circulated.
Why?
We
These are
could not-
two old matters. The first one is the old matter. What is the problem?
Item 10 and 12.
Then why are you seeking adjournment?
We could not prepare it, Your Lordship. That is why we have
You could
circulated.
not prepare.
Yes.
Yesterday you know that it is not prepared. How long does it take to prepare a case? Is that a ground? This was given yesterday. Yesterday you came to know that you would not be able to prepare this case. Don't give these kind of grounds. You pray for an adjournment, we'll grant you adjournment, but not on these grounds. This was by circulation yesterday.
Yes.
So, does it make any sense? A prayer for adjournment has been made on behalf of the petitioner. List on Tuesday next. Separate orders 10 and 12.
Deeply opposed.
Make this, Lordship. Lordship, item number 7, Lordship.
Yes.
This item, Lordship, some of the documents which were exhibited in the trial court, Lordship, were not inadvertently annexed with the writ petition, Lordship. So, Lordship, we may be allowed to file an additional affidavit, Lordship.
After how many years?
Lordship,
After 8 years. Sorry.
only 2 days, Lordship.
No,
time will be granted.
we should have done all these years.
Yeah, Lordship.
From 17 it is pending. Sorry.
Lordship, some the new
Sorry,
documents.
sir. We'll take up the matter. Then we'll decide.
May I please, Your Lordship? I beg to mention for listing one writ petition, Lordship, for Thursday, Lordship.
Writ petition for what?
FT matter, Lordship.
FT matter, not Thursday.
Addition column, Lordship.
Not Thursday. Let it be on Monday. Matter of which year?
2022, Lordship.
Monday.
Much obliged.
My Lordship, I beg to mention, I filed one IA, my Lordship. Here the petitioner has been arrested, my Lordship. The petition is pending, my Lordship. Tomorrow is coming. Can it be fixed tomorrow?
Tomorrow the matter is fixed.
Fixed. Matter item number 22 and item number 1.
Tomorrow.
Tomorrow.
Okay, you can have this IA also.
Please.
No, this one, sir. No. Yes,
Item, page 38 is the improved opinion, my lord.
yes, page
39,
39,
38.
38. Yes,
Here, page 39, my lord.
hmm,
From records, middle part, my lord. It appears that OP tried to project Babur Ali Sheikh as his father, whose name is recorded in the voter list of 1959, Exhibit 1. The name of voters in Exhibit 1 are Babur Ali Sheikh, Sabit Ali Sheikh, Umar Bawa, Burburi Bibi. Exhibit 2 is NRC voter details in the name of Babur Ali Sheikh. These documents pertains to village Korsamari under the district of Dhubri. In the Exhibit 3, as per OP, his mother Burburi Bibi is recorded. The voter list pertains to village Sastapara under PS Vileshwara of the year 1971. In exhibits 4, 5, 6, 7, names of OP recorded with his wife Kodiron Bibi in a different village. These are the translated copies of voter list of census of village Durgapur. These voter lists are not sufficient to establish linkage with his projected father. Though his name is found as son of late Babur Ali, we are unable to prove that Babur Ali and Babur Ali Sheikh is one and same persons. That apart, age of OP is shown as 38 years in the voter list of 1997, which probably be the first voter list of OP. Going by this, his age, his name ought to have been recorded prior to 1997. OP has not stated anything that what has happened to Babur Ali and Burburi Bibi. Exhibit 8 is the electoral photo identity card of OP, and his relation is shown as Babur Ali. These documents render itself as insufficient unless linkage is proved. Moreover, apart from not being proved and is post 1971, in this case, his relation's name is shown as Babur Ali instead of Babur Ali Sheikh. Exhibit 9 is the name correction affidavit shown by the OP on so and so. Affidavit is not considered as valid piece of documents, which the meaning of section 1 of 3 of the Indian Evidence Act. Derivable to Abdul Aziz claim himself as younger brother of OP. OP has not stated anything that he has brother, namely Abdul Aziz. Evidence of DW2 and DW3 are found contradictory, hence unable to trustworthy. Exhibit 11 is the cell deed 1997, in the name of Iman Ali, DW submitted his voter ID where his relation name is recorded Babur Ali instead of Babur Ali Sheikh. Therefore, rendered itself unreliable. The affidavit shown by DW2 explaining discrepancies of name in the voter list cannot be considered as a valid piece of evidence. Therefore, DW2 has failed to submit any supporting documents. Establish linkage between DW2. The OP, none of the documents submitted by the DW is proved according to the procedure of law. This is the judgment by law. Now you'll also kindly see written statement held by the page 12. Paragraph 4, my lord. That the case is not maintainable for not complying with mandates of the provisions of laid down under section 3 of the foreign statements of the Swensu, that the SP Bongago is bound to state the grounds upon which the opposite party has been arraigned to be foreigners. But the notice served upon the opposite party does not disclose any ground as to why the opposite party has been arraigned as foreigners. Hence, this present proceeding liable to be dismissed. Here I will also mention that the inquiry report as well other findings has probably not served to the petitioners. Inquiry report is to be served. That has been not done. And other grounds also, but I will come on that. Now, it is bounden duty of the citizen why suspicious has arisen in this regard to his status as a citizen of India, so that he may be able to show that the basis for suspicion is ill-founded. The authority to state clearly who doubts the status of a citizen of India, so that he may be able to show that the basis of the suspicion is ill-founded. That requirement has not been also followed. In this regard, decision judgment has been come, I will place in the matter. Now, illustratively, paragraph 7, that opposite party born and brought up at village Kursamari, Tube, so PS Sapor, district Dhubri, Assam. His father's name is Babur Ali, alias Babur Ali Sheikh. His grandmother's name is Godulu. His mother's name is Burburi Bibi. That the father's name of the opposite party has been recorded in the voter list of Swenso under Swenso Assembly, the then district of Golpara, subdivision Swenso, village Kursamari, Union Swenso, as Babur Ali Sheikh, son of Godulu, Bonavide citizens of India. Annexure, this is exhibit 1. Now, you look at paragraph 9. Ojapati, his father, along with his mother, shifted to village Sastapara. I clearly mentioned that they have shifted. Under 39 nong of Kukrajar Legislative Assembly constituency from village Kursamari. And during the period of staying there in, the mother's name of opposite party has been recorded in the voter list of 1971 under Swenso, LSC, subdivision Swenso, Sastapara. Now let's look at LSC, paragraph 11. That previously the opposite party resided at village Sastapara of Kukrajar, BTD, and during the period of residing therein, a great communal rights arose at Boruland, and as such, the opposite party, along with his family members, took shelter at village Durgapur under Balajani Sasabani Soronati Sibir, Obeyaburi police station in the district of Bangagaon, Assam. And during the period of living therein, the name of the opposite party is inserted in the voter list of 1997, Swenso, village Durgapur, Nong Swenso, Balajani Sasabani. My case is Balajani Sasabani. Soronati Sibir, Bedo Khalgari, it is mentioned. Police station of Ivory, subdivision Swenso. Then, my lord, paragraph 12 also, that the name of the opposite party has been enlisted in the voter list of 2010, village Balajani Sasabani. Now 11 also Balajani Sasavani, 2011 voter list, Balajani Sasavani. Now paragraph 13, my lord, that the name of the opposite party is also inserted in the voter list of 2015, first name Sensu Balajani Sasavani, number Sensu polling station, website, police station Bongaigaon, subdivision Bizni, district Bongaigaon, Assam, Sensu. That the name of the opposite party has been recorded in the voter list of 2013 having voter ID number Sensu, Babadi Bonavide. Now 13, my lord. Observed during the period of residing in at Balajani Sasavani, he passes a landed property situated at revenue village, Koimari Laharapara, and the Sijangram circle of Abari in the district of Bangaigaon, Assam covered by Swensu. Those are the documents and those are the statements made in the written statement. And from the records, my lord, I found that the evidence of OP, although he submitted the evidence affidavit, but he has not been cross-examined. He has not been cross-examined. And directly cross-examined the DW 2 and 3. I find the order sheet also on records. He has not been cross-examined by the and order sheet also did not disclose that he was cross-examined. And no date fixed for his cross-examination in the order sheet also I found. So DW 2 and 3 has been cross-examined. Then they supported the case of the petitioners. Now, my lord, you'll also kindly see the annexure 1, no, annexure page 41, the voter list of 1960, 59. Kusmari, he is the original village. Father's name Babur Ali, and mother's name serial number 11, Burburi Bibi. And page 43 is the NRC, my lord. Babur Ali Sheikh, village Kusamari. Page number 44 also, Babur Ali Sheikh, Kusamari. No, the original, my lord. No. Next page 45, voter list of 1971, village Sastapara. We shifted from Kursamari to Sastapara. In the 1997 voter list, page 47, name of the petitioner and his wife appeared. In 2010 also, and those documents has been not accepted because those are translated copy. But however, those are certificate copies, my lord. The authority supplied this, my lord, certificate copies.
Page 44 is certified copy.
Page 40.
4? What is 44?
Oh, 44 is not a certificate, it is a downloaded copy, my lord. That document has been prepared during the upgradation of NRC. It is a legacy data. The 46 is the certificate copy. 47 also certificate copy, my lord.
The 44 is with regard to whom?
44 is regard to father,
What is his name?
Babu Ali Sheikh. Babu Ali Sheikh.
This is Babu Bali.
Babu Bali, it is written Babu Bali.
Babu Bali.
And voter list and Babu Ali Sheikh.
There at page 45 is the voter list of which year? 1971.
1971. And 46 is the original, my lord.
1971.
And 46 is the original.
Your mother is there.
Yes, mother is there.
Puri Bibi. Yes. Thereafter, in page 47,
47 is the 1970, 97,
hmm,
1997 voter list. Name of the petitioner appeared with his wife. Voter list original to this person. Voter list product.
Iman.
How was the person? What is the revolution for?
So the first voter list,
My lord,
the first voter list where your name has been reflected is of the year 1997.
97,
Your age is 38 years.
38 years.
How do you explain this?
Because they are shifted from another place to another place. In between, the voter list has been prepared. Could not be recorded.
Where have you stated?
It is not mentioned here.
Huh?
It is not mentioned
The
anywhere.
question we'll have to answer this.
Yes.
Your age is 38 years
Yes.
in 1997.
Yes.
You have at least got a chance, at least in 4 previous.
Yes. 80, 89.
Yes.
Voter
We
list.
have not given the first
But-
voter list is 38 years.
But if you also kindly see that
We have to connect. We are
yes.
the connection, linkage.
It is it is not mentioned here anywhere. In written statement, it is not mentioned why his name not appeared. But
No,
from
Mr. Ahmed, the explanation which you are trying to now give that there was shifting,
yes,
have you stated in your written statement affidavit?
that is why I mentioned written statement not mentioned.
Affidavit,
The affidavit also, the written statement, examination sheet, file an affidavit, not mentioned. So you'll also kindly see my evidence in chief. Page 18. Page 18, my lord, paragraph 8.
page 18.
Page 18. And you'll also kindly see page 20.
20.
Paragraph 5. that due to erosion of river Champa, our landed property and house are lost, and my father shifted from Kusamari to Bless Sastapara, so and so. Now let's
Paragraph
see
5.
para 5. It is that thing mentioned is a written statement also regarding shifting. Now paragraph 8, my lord, that in the year 1991, due to poverty, I along with my family members shifted from Sastapara to village Durgapur under Sirang district VTAD. That in the year 1993, our houses were burned down by some miscreants, and we are driven out by them from the said village, and then I, along with my family, was sheltered at Balajani Sister Civil. So, in between brutalist people,
When was the first shift from due to erosion of river Champa?
paragraph 9 of the written statement, page 13,
Yes.
the Wazir party, his father, along with his mother, shifted to village Sastapara and the Senso Legislative Assembly constituency from the village Kursamari. And during the period stating herein, the mother's name of the Wazir party has been recorded in the voter list of 1971.
First station entry, 27. 38 years.
Judgment no, it was judgment. Lawyer. Lesson, huh?
Yes.
My lord,
Yes.
I have gone through the order sheets. That uh, although the petitioners are all along appeared before tribunal, and but he has not been cross-examined. And he adduced other two evidence witnesses, DW2 and 3, they were cross-examined. And so the evidence submitted by the petitioners is hold a field, my lord. Well, because his evidence has not been challenged. And on the sheet, I find that it is the duty of the tribunal to cross-examine. At least the date fixed for cross-examination of the DW1 OP. No such order has been found in the order sheet. And directly they have taken fixed the matter for cross-examination of DW2 and 3. And DW2 and 3, DW2 is his brother, and DW3 a cousin, his uncle's son, DW3. My lord. Then, my lord, in book judgments, if you also kindly see, basic findings of the tribunal below is that the voter list, projected voter list, where translated copy could not be accepted. However, those are the certificate copies and exhibited by the tribunal, duly exhibited without any objections. And now, they rejected the evidence of DW2 and 3 because they said a contradictory. What nature of contradictory did not discuss? What nature of contradictory of DW2 and 3? Only basically that reasons and some discrepancies of name appeared in different places of his father. The petition has been declared as foreigners. Compile. Evidence certificate online, and evidence certificate as well. Online, wait, yes, right. There is evidence. Evidence section 50 by 7. 50, 59.
Page 2049. Mr. Ahmed,
Hello.
kindly come to page 49.
My left.
Voter list of which year?
2011.
11. See, in the same house, you have the petitioner,
Yes.
correct?
Yes.
Imam, then his
My wife.
wife, Tasiran.
Yes.
And this, who are the others?
Others his family members, but they did not disclose who are there.
No, family members, or how, what connection? Who is Javed Ali? Javed is not your brother.
No.
You name two persons as your brother, one has passed away. One is there who,
Rapidly, I could not say, and they also not mentioned in evidence in say or written statement. But
you are in the same house,
in the same house, but
72K.
earlier when they said the uncle. Zabed Ali is the uncle.
Uncle means how uncle? Whose father, whose
But,
son?
but he is not confirmed, my lord. I am not raised question.
Then, if this is your statement, then we come to the question which was put to DW two.
So he could not say who is Hasan Ali. I can't read. He could not say
Why?
who is Hasan Ali. But in DW2 is living separate place. His cousin brother.
His brother stays with some family members. He doesn't even know who is he or she.
Yes. Stated. It is on record. It is on record, but it does not means that my case is false. It does not means, my lord.
You don't.
My lord, I may not.
You don't even know your relative.
Yes, I may not say something on records. It does not mean my case has been weak.
Question
It
was
is not.
put to you. You're not
No,
saying,
yes,
that's saying you're not saying you're not disclosing. That is also fatal.
my lord.
We go one step ahead. We
Yes.
give you the benefit of doubt. You have to answer the question. You
My
said,
lord,
I do not know who is he.
My lord, in some cases I found in one house 50 persons. Different. Then I asked them why those persons, because sometimes what happened, they in same house, same number,
Ahmed, we can go
700
back.
persons name has been included.
Hypothetical example of 50
Yes, my
persons.
lord.
In house there may be 150
My
persons.
lord.
Here is a house, we have got 4 members.
My lord.
You
But
don't know the members.
yes, it is facts. I
Yeah.
got this. I am not
How do you
disputed.
overcome this?
Yes, I am not disputed.
You have to have an answer which is
Then
reasonable, acceptable.
Then other factor is to be considered, my lord. Whether my name appear in the 97 voter list, which is very
97 is post 71. You are 38 years old in 97. You don't have a single voter list prior to 1997.
then in the my lord,
Most simple question you have to answer.
my lord.
You answered this matter and
Correct. It is correct. But reasons he has stated,
you may shift. Shifting we may accept.
my lord.
Shifting will not mean that you don't have a voter, your name in the voter list in the earlier place. You produced the earlier voter list. Yes, it was there, but I had shifted. So in the new voter list, my name is not there.
My lord, what happened in
And 97 is not 1
enumeration?
year, at least 4 years. At
Yes.
least 4 voter
Yes.
lists.
Enumeration has been made, not year to year. It is after some years.
After
it
at
has
least
been
5
done.
years,
At least 5 years.
then also 4
But
occasions.
when that position is come, we shifted. So question of his name
Every time,
appear
for the
in
5th year you shift.
because it is a record.
Difficult to accept.
Because it is a record that they are in detention camp. Their house has been burned down. They are in detention camp more than 12 years.
In detention camp, there is no enumeration.
That is why 97 voter list has
So there was no enumeration before.
enumeration, but their detention camp.
No, before 97,
The enumeration is
97
there.
to 38 years, you became eligible at 21 years.
My lord.
From 21 to 38, how many years?
But enumeration, so far a record I found, enumeration has been done in the year of 1997. His name included.
No,
Well,
your
he was his
explanation-
detention camp.
Your explanation has to be a reasonable one, acceptable one.
You'll also kindly see in again.
Even if we accept your argument
Yes.
that the later voter list translated copy, which the tribunal took a view that we are not going to, we take those into account
Well,
because those are certified copies.
my lord,
We
again,
take those into account.
you'll see I don't page 20.
20.
Again, my lord. For consideration, my lord.
20.
1991 he was accepted.
Hmm.
Then 1993 burned down, and he they are in detention camp, Sarnati Sibir for long periods. And while they were in Sarnati Sibir, he page 21, my lord, their name entered in the voter list in 1997 voter list entered. 1997. Even 1997, they are also Sarnati Sibir, my lord. 1997. And while he was in detention camp, my lord, he purchased a plot of land in the year of 2000,
See, let us again re-examine from your context.
my lord.
You're trying to project that in 93, house was burned, you've gone to the the relief came in 97 enumeration. Let us again come back to paragraph 5. Okay? There was erosion of Champa.
Yes,
Then you shifted to Sastapara
yes.
in 1971. Okay?
No, no.
Yes.
1971 voter list name appear here, madam.
Mother, you
Name appear. It means before 71 they shifted.
they shifted. Let us see. 71, you are not there.
Yes,
Let us assume. 71, you are not there. Your mother's name is there in Sastapara because you shifted because of erosion of Champa.
from
71. Then you say that in 1991, you, due to poverty, you shifted from Sastapara. Correct?
so to village Durgapur.
Durgapur. So that means from 71 to 91, that period, you are in Sastapara.
Yes,
Now, when did you attain the age of majority to vote? The year?
85 my lord.
Huh? You were 38 in 1997.
1997.
1980, he becomes eligible for vote. Let us give one more year, 2 more years. 81, 82.
80, 85, 89 voter list, his name is to be recorded. But
From 80,
85 and 89.
from 80 to 91, let us go by your explanation.
Yes,
In
not
11 years, you are at Sastapara as a voter.
my lord,
Your name is not there.
not there. But sometimes it is heaven. Sometimes it is heaven. Sometimes they are not poor men to different places for working. In the meantime, persons come, found no one has been found in the house. This is
Okay.
one of the reasons.
Yes, Mr.
Then, my lord,
Anything more?
my prayer is, my lord, since I have not cross-examined, and the moment I examine some witnesses, produce my cases, it is the duty of the authority to rebut our findings, our contention.
No, we'll go by your evidence unrebutted.
Then he is to be challenged, my evidence. Now, one thing. Now, second thing, my lord, procedure has not been followed in accordance with law. I place one Supreme Court judgment recently.
Which procedure?
Procedure, my lord, they did not have the inquiry, copy of the inquiry report, ground of suspicion, nothing has been supplied to me. So we could not properly represent our case before the tribunal. The lawsuit, can you see that judgment recently come on judgment?
See, the allegation is a simple allegation that you have to prove your citizenship.
No,
Are
my
you
lord.
required to understand
My
more
lord,
than that?
And the question is, my lord, on what basis? What is the suspicion?
No.
And on what basis?
Those are not required. Those
It is
are
there.
once the reference is made, the burden shifts
No,
upon you.
it
You
is
prove
there.
that you are a citizen, matter is there. There are many references answered in favor of the
You'll also
proceeding.
kindly see section 3(1) of the order 60 feet back.
Yes,
It clearly mentions
yes.
that has not been followed. Then,
Please read.
my lord, 1. The tribunal shall serve on the persons to whom the question relates a copy of the main grounds on which he is alleged to be a foreigner and give him a reasonable opportunity of making a representation and producing evidence in support of his case, and after considering such evidence he may be produced, and after hearing such person as may deserve to be heard, the tribunal shall submit its opinion. Now it is
You're reading what? You're reading?
main grounds.
You're reading?
3(1).
Section
Yes.
or orders?
Order. Finance order 1964.
Order 3.
3(1) of the Furnace Tribunal's order 1964.
Yes.
Now, you'll also kindly see what is the basis of suspicion. Why they suspected me that I am a foreigner? On what basis? On anyone some complaint, made any complaint? Or they took up Somoto? If they took up Somoto, whether how can they detect that I am come from Bangladesh, on which place? Whether that inquiry officer went to Bangladesh to find out I am come from that village, particular village? That is not done. Most requirement point is there. In this point, my lord, Honorable Supreme Court recently passed on judgment. A lawsuit can you see? Very clearly discussed in this matter regarding service of notice, regarding grounds, everything has been clearly discussed. In the case of Muhammad Rahim Ali, it is also reported in the 2024 SC 3551. No? From my lord, details has been discussed. Now, main point come from paragraph 33. I have not received a copy of inquiry report. What is mentioned, where from I come, I have not known. But certainly there may be mentioned that I have come from so village of Mymensingh or something, Bangladesh, where they got such informations. This is to be disclosed.
Where, which
Yes.
paragraph?
Now you also can see from it is start from paragraph 33. Section 9 of the Act stipulates if in a case not falling under section 22, any question arises as to whether a person is or not a foreigner or is it not a foreigner in a particular class, the persons concerned must prove that he is not a foreigner or not a foreigner so. However, the question is that does the section of empower the executive to pick up a person at random, knock at his her their door, tell him her they we suspect you being a foreigner, and then the rest is the basis of section 9. Let us contextualize this to the facts at hand. The origination point of inquiry is the SP border Nalbari's directions to Sub Inspector Swensu. The pleading and the record are silent as to what was the basis of SP Nalbari's directions. What materials or information had come to his knowledge of position that warrant his direction. Obviously, the state cannot proceed in such a manner, neither can we as a court countenance such approach. First, it is for the authorities concerned to have in their knowledge or possession some materials basis or information to suspect that a person is a foreigner and not an Indian in the present case. Now it is mentioned that from inquiry, it was revealed that the appellant had migrated illegally to state of Assam from Bangladesh after Swenso, but nothing has come on record to indicate even a iota of evidence against him, except for the bold allegation that he had illegally migrated to India post Swenso. It is also not known as to who, if any persons, had alleged that the appellant had migrated to India after Swensu from village Dinapur police station, Torali district, Mymensingh in Bangladesh. It need to reiteration that the persons charged or accused would generally not be able to prove the negative if she is not aware of the evidence materials against him oblique her, which leads to the persons being labeled suspect. Ipso facto, just allegations, accusation cannot lead to a shifting to the burdens to the accused. Unless she is confronted with the allegations as also the materials backing such allegations, of course, at such stage, the evidentiary value of the material would not be required to be gone into, as the same would be done by the tribunal in the reference. However, mere allegation that to being a fact as to mechanically produce simply the word which mirror burden statutorily imposed on him by virtue of section 9 of the Act. The person has to be intimated of the information and materials available against him such that he can contest and defend the proceeding against him. In the present case, it was specifically alleged that the appellant had to come to Assam from village so while making a reference to the tribunal. Hence, it was incumbent on the authority making the reference to provide details as to how it had received such information, as also its bona fide belief of such factum being true. In other words, the authority had been, as claimed, able to trace the appellant's place of origin. Surely then, the authority had some materials to back its assertion. The record does not show such materials was given either to the appellant or the tribunal by the authority. In the absence of the basic primary materials, it cannot be left to the untrammeled or arbitrary discretion of the authorities to initiate proceeding, which have lived altering and very serious consequence for the persons basis hearsay or bold and vague allegations. In neither round of the proceeding before the tribunal, whether it be the initial expertise one or even after the matter was referred to the court, to the tribunal to hear the appeals and pass an order, it been revealed as to how and from where such specific allegations down to the village of origin of the appellant in Bangladesh was brought to or come to the knowledge of the authorities, nor do we locate any supporting materials. In the present case, clearly the authorities concerned have gravely faulted by construing the words, a copy of the main ground on which he is alleged to be a foreigner in para 3.1 of the so to mean the allegations leveled against the persons. This error at the very inception stage is enough to render fatal blow to the entire exercise of an undertaking. The term's main grounds is not
Yes. We have read this.
so, my lord, up to all the paragraphs are very important in this case. Very important. Even in this case, Fabando Sonowal 1-2 has also been discussed. So only on that ground, the tribunal order is required to be set aside. Because procedure has not been followed by the authority, inquiry report has not been served to us, no ground of allegation has not been disclosed to us, for which we could not make our case properly before the tribunal. Now, all the paragraphs from 33 to 51 is very much necessary, my lord. In 51, if we also calculate 51, 50, eventually, paragraph 50, our understanding and exposing of the law in the preceding paragraph can be read with Sarvendra Sonal 1 Supra and so and so. It embodies meaning as to what is expected of the authorities till the stage of section so and so arrive. The statutory burden would kick in thereafter. Now, regarding now regarding discrepancies of name appears in the voter list as already decided in the Sirajul Haq case in the Honorable Supreme Court. In this case also clearly mentions shifting, clearly mentioned in other Fergus cities. Those are not fatal. Merely not appearing my name in the sum of the voter list, it does not mean I am a foreigner. It doesn't mean. Once my name appeared in the voter list of 1997, my father's name, my mother's name appeared before the voter list, anyone voter list of the 1971, I cannot be say that I am a foreigner. Sufficient, one document is sufficient. Moreover, my lord, evidence of render has not been clearly discussed by the tribunal below. Section 50, 59 of 60 of the evidence has completely overlooked. Because section 50, my lord, they showed, we say, PW say, I am the brother. It is a form, so evidence, it cannot be discarded. Either the authority has disputed it, they cannot dispute it. In this regard, I place also some judgment. In the complaint, I place some judgment. They cannot state rejected the evidence regarding relationship, proof of relationship. There is clearly established that proof that my brother said that I am his brother. My one of uncle's brother say, yes, we are the related persons. So section 50 is applicable here of the evidence act. Now will also kindly see that I place that reliance on the basis of that reliance.
Section 50,
My lord,
50 of the evidence.
evidence 50, and then 59 and 60. Hah? Lagi buat. Kasar coba.
Yes.
Your Lordship, the London Tribunal says that those are consented copies is not accepted. And although those documents were exhibited, duly exhibited, no.
But that part we have accepted,
My-
we may accept.
Then, my lord, section, as far as section 50 relationship proof is concerned, on the basis of some judgment, it is 2021 4 GLT, I also given there, 644. Soja Valley, paragraph 18, 19, 20, and 21.
2000,
Paragraph 18, 19, 20, and 21. Soja Valley. Because the tribunal below did not give any findings regarding that relationship, proof of relationship. And this judgment has come on the basis of 2008 4 SCC 75 para 26, 26, 27, 28, and 30. I also place this judgment, my lord. And another is AIR 1959 SC 914, paragraph 6, 7, and 15, page 5 of my written argument. Now, my lord, the learned tribunal below came to a conclusion that Schedule 2 and 3, my lord, their evidence are contradictory, and they did not, petitioner did not mention their name as brother. It's not a matter. It can be raised at any stage. It is in this regard, my lord, 2021 3 GLT, in the case of Hydro Rally, my lord. Details discussion has been made there. Paragraph 24, 26, 27, 29, 33, 39, 40, 41, 46. Paragraph 5 of my arguments. Now regarding my lord discrepancy of age, and it isn't clearly mentioned the earlier judgment. I give somebody lordship, give lordship. Another judgment is Sirajul Haq, 2019, 5 SCC 534, Sirajul Haq, regarding shifting discrepancies of age as name. Now, the tribunal also held that the safe experiment the affidavit of the correction of age cannot hold a field. It is not a piece of evidence. In this regard, also one judgment I relied. It is not reported. It is a WBC number 3578 of 2016. Page 7 of my argument I mentioned. Mustafa Uddin. His legal heirs. Here, the court held in paragraph 15 that the tribunal had no valid reason for ignoring the affidavit filed by the proceedee to explain that Mustafa Uddin are the same and one persons. The tribunal could not have ignored such documentary evidence, as the said evidence is a piece of evidence which can be used to corroborate the other evidence also. Page 1 of 10. Page 3 of 10. Report to me. Report to me. Report to. Record. What is the difference? I want to see. YouTube file. East version. I think a compilation of music. So, মাজত বিলাক নাইকিয়া কৰি দিছো নহয় মই লিখি দিম I'm sure you it will be said declare that it will be followed it might be studied actually is supporters different names of the book he gives an activity to month to was there if you come is given to the office so far as his name is father is concerned it cannot be a declaration. He says my father was attend regularly said. This that is different than this part. Thinking of the difference. There's another data from them. None of the program. Election commission in the photographs and not further than good names. That will be electoral litigation. Balloon electoral litigation. Balloon. It will be of drive. Yes.
So, my lord, my humble prayer.
And my lord, I submitted my argument very long back. Can it be taken into consideration?
Which argument?
My written.
We'll consider definitely.
Then some new point I have raised that was.
We have made notes.
Yeah.
Yes, will be.
May I please your lordship? I have already placed my written argument, lordship, and lordship, my humble submission is that lordship, a learned tribunal has given the opinion on the basis of materials available on record, lordship. And the petitioner failed to establish any infirmity in the opinion passed by the learned tribunal before this honorable court. And lordship, the instant case of the petitioner is that petitioner projected one Babur Ali Sheikh and one Phurphuri Bibi as his parents whose names reflected in the voter list of 1959 at village Kursamari, district Goalpara, Assam. Apart from this voter list, lordship, petitioner could not able to place any voters list of his parents in respect of said village. After that, petitioner exhibited NRC document of his projected father, which is lordship already law has been settled that NRC document is not admissible in evidence, lordship. And lordship, petitioner relies on voter list of 1971. After 1959, lordship, petitioner relies on the voter list of 1971 of different villages. Of village Sastarpara, district Goalpara, Assam, where her projected mother's name appeared as a sole voter, lordship. And although the petitioner in his evidence stated that due to erosion of river Sampa, they have shifted from village Kursamari to village Sastarpara under Section 9 of the Foreigners Act, lordship, burden is on the proceedee to prove that she is not a foreigner but a citizen of India. And this burden never shifts, lordship. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevance to the facts in issue. These are settled position, lordship. Here in this case, lordship, there is no documentary evidence placed by the petitioner to prove that the family of the petitioner has shifted from village Kursamari to village Sastarpara. Nothing is there, lordship. And lordship, my humble submission is that law has already been settled, lordship. Oral statement is not enough, lordship, to establish one citizenship in case of foreigners case, lordship. Here only statement that they have shifted from village Kursamari to village Sastarpara. When they have shifted, when his father died, was not mentioned in the written statement as well as evidence. And lordship, written statement is the basic statement of defense of a proceeding in respect of foreigners case, lordship. And proceeding cannot go beyond pleadings, lordship. And regarding that, lordship, so many settled law has been, so many decision has been passed this by this honorable court, lordship. And after voter list of 1971, lordship, there is no voters list of the projected mother or father of the petitioner is placed before the tribunal to prove that father or other family members are continuously residing in the state of Assam, which violates the mandates of Section 682 of the Citizenship Act 1955, Lordship. And so continuity must be there, Lordship. And Lordship, if your Lordship permits, Mr. Payang may be allowed to submit, Lordship.
We want one council to, whoever does, but we don't want two
Yes, sir.
councils to submit. If
Only one
Mr.
to
Payam wants to submit.
one, yes. Well, your lordship, we have already submitted a written argument, probably it is there in,
So we are, Mr. Ahmed has,
yes.
Towards his last part of argument, he has placed reliance on AR 2024,
It's, I'll come to-
3551.
Yes, madam, I'll come to that
That
point.
one, paragraph 33. He has also placed reliance on the relationship, paragraph 21 of Suzab, the division bench, and also Sirajul
Yes, Suraj.
on the discrepancy of age. This mainly the Honorable Supreme Court judgment in Rahim Ali.
Yes, madam, I'll argue on that one. But first of all, I would like to show your lordship. Your lordship has heard my learned friend, my friend, and your lordship has rightly pointed out, my lord, that since, my lord, 1971 to 1997, there is no documents at all of the petitioner. What we want, my lord, a person whose name appearing suddenly at the age of 38 years in a voter list is, first of it is doubtful. First of all, what we want, my lord, we want that the at least earliest convincing document by which he can show that he is a citizen of India. He is there in the state of Assam. Earliest documents at the age of 38 years. We expect at least at the age of 21 to 25 years, his name should be there in the voter list somewhere. And to this explanation, to that issue, there is no explanation on the part of the petitioner. And he has brought to evidence witnesses, my lord, whose name were, he is claiming that one of his brother, one of his cousin brother, they were not introduced in the, my lord, WS. Whether there is any brother, whether there is any sister, whether he has any cousin, those are not mentioned in the WS, my lord. Suddenly a person has come and saying that I'm the brother of so-and-so. Those are not facts which were pleaded in the, my lord, WS. And in WS, my lord, if we see the WS, he has given a, my lord, elaborate WS, but it's vague to tell you. Your lordship has seen, he has said that his father was a voter in 1959. His mother was a voter in 1971. What happened thereafter? Where are the father and mother after 71 and 59? He has not disclosed any. Whether the father is dead, whether the mother is dead, why the father and the petitioner or mother and petitioner is not a common voter in any of the voter list. Those things are not there. Now, presuming, my lord, that his name is appearing in the 1997 voter list. My lord, he may come in the 1996. He may enter his name in 1997 voter list. And then, so that cannot be that his name is appearing in the 1997 voter list, so he is a citizen of India. That cannot be, my lord. That is certain position this court has again and again says, my lord. The Honorable Apex Court has also said, mere enrolling in the voter list is not a proof of citizenship. That is there in the, my learned friend will show, my lord. Now, my lord, the issue which my learned friend is arguing, in fact, this is a bigger issue, my lord. That, my lord, the person, whether the initial doubt has to be created by the state government. Then we have to go back to the IMDT again. IMDT was set aside only for that issue only, my lord. While dealing with that issue, the Honorable Apex Court has said, your lordship may kindly see the Sobanando Sunal 1, my lord. I'll show your lordship what is the Sobanando Sunal says with this regard. My lord, this is, if your lordship have the 2005 5 SCC 6 piece 5, my lord. Also, I'm reading just
2005?
5 SCC, my lord. 665.
Yes. Para?
Para
41 and 42, my lord. And secondly, my lord, my learned friend is arguing that ground should be there. It is settled position of law by this honorable court also that if the ground is mentioned in the notice itself, no separately, there need not be separate grounds that given matter. It's contained in the, my lord, in the notice itself. If your lordship may have the, my lord, record, it is not annexed here. Record, it is said that the state government, the SP concerned has doubted you to be a foreigner of 071 as per Foreigners Act 1946. So you are therefore asked to appear before this honorable tribunal to explain, to show that you are not a citizen of India. That is, the reason is given. The SP concerned has doubted you. After an inquiry reports are there. After an inquiry reports are there. Those are case report, case diary that cannot be furnished. Case diary cannot be furnished. The grounds is there. Ground is there in the notice itself. This honorable court has says, if the ground is incorporated in the ballot notice itself, no separate ground need to be served. That is settled. So the ground is incorporated in the notice itself. Now, what para 41 says, my lord, as my learned senior friend is arguing, that my lord, where from he has come, why he has come, those are not given by the state while my lord initiating the process. What Supreme Court has said while dealing with the, my lord, the IMDT, because IMDT wants that only. That's why the Honorable Apex Court has set aside IMDT. No, it cannot be provided by the state or anyone, any other agency, because it is impossible on the part of the state or by any person who is alleging that he is a foreigner, because it is his personal knowledge. It is the person's personal knowledge who has come from East Pakistan, who has migrated from East Pakistan. If he doesn't disclose all these things before the investigating agency, it is not possible on the part of the investigating agency to find out when he has come, why he has come, where from he has come. This is what Honorable Apex Court says in this matter. In para 41, 42, 41 I am reading matter. Rule 4 requires, this is rule 4 of the matter, IMDT. Rule 4 requires an inquiry officer to be elicit information. I'm reading slowly, man. Rule 4 requires an inquiring officer to elicit information and particulars from the alleged illegal migrant on the points of national mention form number 1, item 5, 10, 11, 12 of this form are under. What are the address in the country of origin, village, police station, district, and country of origin. That was IMDT 6. Does the persons hold any passport issued by the foreign country? If so, furnish particular whether what are the reasons for leaving the person's country of origin? If the person has entered in India without passport, how the person entered in India, name, village, district from which the person entered, and date of entry. These were the requirement in the IMDT as per rule, IMDT rules. Now my learned friend is asking for that only. And this honorable, what the Honorable Apex Court says, page 42 to that reference matter. It is elementary that a person who has illegally come from Bangladesh to India and is residing here for his better economic prospect or employment, etc., would never disclose that he has come from Bangladesh, but would assert that he is an Indian national and resides in India. There is no question of his telling his date of entry or giving his information on the aforesaid points. According to Rule 7 and 8 of the rules, the inquiry officer has to submit a report form number 1, that is item number 5, 10, 11, 12 are exactly identical to the Rule 10, 10A, 10B laid down in the applications to the tribunal under section 8(2) shall be made in form number 3, and application to the central government under so-and-so shall made in the form number 5, and declaration under section so-and-so shall be made in form number 5 and 6. Curiously enough, column number 6 of form number 3 requests the applicant to furnish the following information regarding the alleged illegal migrants. Again, the same things, my lord. Whether he entered on or after 25/3/71, date of his entry into India, whether he is a foreigner, and whether he entered into India without being processed or valid passport or travel documents of or lawful authority in that effect. Now, my lord, then it is discussion is going on, but in the para 42 first per line itself, he is not going to disclose all these things. So, on the basis of these observations, my lord, para 83, all this has been set aside by para 83 of the my lord, Sabananda Sunwal. The rules have been set aside on the basis of which this, my lord, these informations were sought by para 83. Sum up to our consideration the provision of Illegal Migrants Act 1983, ultra vires to the Constitution of India, the Illegal Migrants Determination Rule 1984. This rule was, my lord, under this rule, all these informations were asked. Rules are also virus and struck down. So what that, my lord, this information, now my learned senior press is asking, this information is not there. So the inquiry is false, illegal. And this stent was not taken in the WS. This should have come in the very first stage itself. He has not taken these steps, my lord, arguments plea before the my lord tribunal. And while my lord, my submission, while honorable, in fact, I may not have my submission is that while honorable apex court in dealing with this my lord, judgment, my learned friends judgment, my lord, this aspect of this judgment, this is by my lord, three bench judgment. This aspect, this Sabananda Sunwal is by three bench judgment, that is division bench judgment. My lord. This aspect of the matter was not considered.
No, that was placed.
That was placed, but
Placed.
this aspect, this para 41, 42, these were not considered. These aspects were not considered.
This Sarbananda one is by how, what is the strength?
Three judges bench one. By Honorable Justice C.J. Lahori, G.P. Mathur, and P.K. Balasubramanian. The present judgment is of division benches. With regard to notice, my lord, I have submitted that notice, it is incorporated, the grounds is incorporated, my lord, notice itself.
Then come to the paragraph 36 of this judgment. Paragraph 36.
Para 36, my lord.
For that matter, 33 or not, 33, 34, 35, 36.
33, section 9. 33 dealing with section 9.
Yes.
Yes. Section 9 of the Act stipulates if a case not falling under section 8 of the Act, any question arises as to whether the person is or is not a foreigner, or is not a foreigner of particular classes, the person concerned must prove his or his foreigner, not a foreigner, and the case provision anything in the evidence set. That is true, my lord. There is no dispute on that. However, the question is to in the section 9 of the Act empowers executive to pick person at random knock his or her door, tell him her his or we suspect you to be being foreigner, and the rest easy basis section 9. Let us contemplate that it is the facts at hand. Original point of inquiry of SP Nalbari, direct the SP concerned so and so. The pleading and the record are silent as to what was the basis of SP Nalbari's direction. What material or information had come to the knowledge of person that warranted his direction. Obviously, the state cannot proceed in such manner, neither can it proceed to such a process. It is there in the record, madam. The inquiry is there, madam. Whether in that case, particular case, this is in particular case, whether there was inquiry report or not, I don't know, my lord. But here it is an inquiry report. The inquiry report is available in the record, madam. as yet. Because it is a case diary, my lord, it cannot be handed, it cannot be given to the my lord, the my lord, the petitioner, my lord. We are not on that because we don't know, my lord, whether there was inquiry report or not in this particular case. We are not saying, my lord, if there is no inquiry, obviously, my lord, if without inquiry, it cannot be. If there is an inquiry, because, my lord, why I'm submitting, my lord, IMDT again. IMDT, there was
No, see the last line in paragraph 34, last sentence.
yeah, obviously,
It is not on the whether an inquiry is there or not.
yes,
Last sentence, what materials or information had come to his knowledge or possession that warranted his discretion?
direction.
No, his direction, right,
Yes.
right.
What?
Obviously, the state cannot proceed in such. He has gone one step ahead.
Yeah. Yes. This is my humble submission, my lord. This is in my lord contradiction to the Sabananda Sunwal.
That is.
Yes, in
that
contradiction
you
to
would like to, you'd like.
Sabananda Sunwal para 42. Because para 42 says it cannot be. State cannot elicit my lord, collect all these materials because it is his personal knowledge. He has to give all these things. If during the inquiry he doesn't provide all this material, how can I collect it?
36 and 37, please read.
Yes. 36. In the present case, it was specifically alleged that the appellant had come to Assam from Soincho, district Soincho in Bangladesh, while making a reference to the tribunal. Hence, it is incumbent on the authority making the reference to provide. That's why, again, it is contradiction to para 42, my lord. These documents cannot be, this information cannot be provided, but it is where larger bench of the Supreme Court has already decided all these things. These were not placed. These were not placed, this para 42 and 41. Had it been placed, my lord, this would not have come. Otherwise, we'll have to go back to IMDT, my lord. We have to again take result of IMDT where there was a procedure for application by some person that I doubt, and on that basis, my lord, the police will make, my lord, inquiry. Then the person have to give an affidavit. Yes, these informations are correct. This procedure has to be followed. In fact, my lord, our part, it's off the record. I can say, my lord, we have already asked for reviewing of this opinion, my lord, this judgment, because this is contradictory to your Sabananda Sunwal. Record your number apex code. And in fact, my lord, so my submission is it is the larger bench decision, Sabananda Sunwal. So it will come into. And obviously, this para 42 and 43 was not placed. And this was not considered while passing this judgment.
One more argument, Mr. Ahmed is saying that
Contradiction, man.
the affidavits regarding this inconsistency in name, there is a judgment as per which such affidavit are to be taken as evidence.
My lord, to clarify the contradiction in the name.
No, the judgment says in paragraph 9, one of the issues is that exhibit 9 is an affidavit in support of, in that judgment, okay?
Yes.
We're just giving you the date. Date is 1/4/2021 in WPC 3578 of 2016
Parties
on the death of Mustafa Uddin.
Mustafa Uddin.
Yes.
Mustafa Uddin, my lord.
Yes. And there is one of the issues. Exhibit 9 is an affidavit in support of different names of the OP to be read as Mustafa Uddin instead of Mustafa Ahmed. However, Exhibit 9 is not a valid piece of documentary evidence in support of his nationality of India as per the Evidence Act. That was the issue.
Yes.
That has been answered in favor of the proceeding by the High Court. So he is relying upon two affidavits self-declaration, one by the proceeding, one by DW1, saying that the name of the father.
My lord, I'm in fact, my lord, even though assuming that that is correct, my lord, only question your lordship is to answer, he has to ensure, my lord, whether he is a citizen of India or not. I'm, my lord, ignoring the discrepancy, my lord, ignoring the discrepancy of the name of the petitioner. I accept, my lord, his name may be something somewhere.
No, his name, his father's name.
Father's name, my lord, how can I correct my father's name? By swearing an affidavit. Yes, I can sense my name, my lord. I can correct my name. Can I sense my father's name by swearing an affidavit? It's my personal knowledge, my lord. It's not the knowledge of the father who is no more there, my lord. The person who is no more there. Can I sense the name of the person who is no more there?
Mr. Ahmed, we have seen that case.
My lord.
In that case, OP has given an affidavit of two names.
Yes,
Here in this case, it is for the Babur Ali's sake. We were discussing with my brother. Affidavit was not by Babur Ali. Somebody says, no, Babur Ali Sheikh and Babur Ali are the same person. Not the same, not him.
being a son, he can. Being a son, because he know his father names, so he can.
First of all, my lord,
can, my lord.
let him prove
No
he's the
problem.
son of that person, my lord.
He can, my lord. Because
By
after
some
everything is shown by the son.
No, you can declare anything on affidavit, but
No.
how much will that be admissible?
Yes, yes.
Question is that
Now my friend says that play has been taken in the written statement regarding inquiry, my lord. Specific play has been taken. No inquiry, nothing, paragraph. I clearly mentioned in my written statement.
not inquiry. I'm not saying inquiry. Inquiry is done, my lord.
Then
I'm not on inquiry.
so when did your father pass away?
That information is not there.
Father pass is not mentioned before 1971.
And mother?
Marriage after 71. No, especially
very
that,
vague.
especially that not given.
It will be very vague.
Is it-
1971 maybe yesterday also.
Yes. For 71, my lord. After 71, it may die.
Not if mother alive, then certainly her name appear in the 1970.
That is why we have asked you, when did she pass away?
It is not mentioned.
Thank you.
It is,
You know that there was a change in the name of your father. You do not know when he passed away.
but definitely he can say, but that question has not been put.
No, it is not required to be put. You have to say it. My father
Yes.
passed away in 1959. My mother passed away
While
19,
making a written statement, there is some talk with the client and lawyer regarding such information has not been taken. My petitioner has not given such information.
No.
When his father expired, when his mother expired.
Okay.
Now, my friend says that
Eta line quick. No, only another aspect, your lordship was relying that, my lord, my learned friend was relying that Sirajul Haq, my lord, with regard to discrepancies in the name.
Yes.
Yes. What Sirajul Haq says, my lord, I'd like to read out the para 3 of the Sirajul Haq. Because their only mistake was, my lord, Kapatullah become Kamatullah.
That's true.
All the other entries were
Yes, we
consistent.
have dealt with
Yes.
Capitula in
Yes,
one of the
Kamatullah.
cases.
Yes, madam. My submission is that had there been a common voter list where other persons were, my lord, consistent, the name of some 1, 2, where their names is, my lord, if their names are, my lord, contradictory, then we can accept it. But if the other entries must be consistent, that is the proposition there in, my lord, there are 3 of the, my lord, this Sirajul Haq. And we
say, regarding inquiry, my friends have read that paragraph 4 of my written statement, I clearly mentioned that
inquiry is not proposed.
4 of your written statement, which
Re-
page?
page 12. Specific play has been taken in my written statement. And in notice also no ground expect suspicion.
Notice ko na next one.
Page 12, what?
Written statement, my lord, para 4.
Okay.
No, my lord, my regarding discrimination in this judgment, particular judgment, also paragraph 41. The recent Supreme Court judgment, paragraph 41, 42, 43, all paragraphs are very relevant in my case. The evidence produced before the tribunal by the appellant to indicate his parents had been reasons so, whereas his siblings and he himself must prior to so, has been disbelieved only on the ground of mismatch of actual English spelling of the names and discrepancy in dates. As far as the discrepancies in dates and spellings are concerned, we are of the view that the same are minor in nature. Variation of in name spelling is not a foreign phenomenon in preparation of electoral rules. Further, the electoral rule has no acceptance in the eye of law insofar as proof of date of birth is concerned. The casual entry by the enumerators when noting the and entering the names and dates births as also the address of the persons while making preparatory survey for purpose of preparing the electoral rules cannot visit the appellant with dire consequence. Moreover, in our country, sometimes a title is prefixed or suffixed to a name such that the same person may be known also by one or two alias. The tribunal seems to have been totally oblivious to all this. The state of Assam, as per Swensu's report, with female Swensu. However, this was not the case during the Swensu. Not just in Assam, but in many states. It is seen that names of people, even on important government documents, can have and do have varied spelling depending on them being in English or Hindi or Bangla or Assamese or any other language for that matter. Moreover, names of persons which are written either by the persons preparing the voter list or by the persons making entries in the different government records, the spelling of name based upon its pronunciations may take on slight variation. It is not uncommon throughout India that different spellings may be written in the regional vernacular language and English. Such same person will have a definitely spelled name in English and the local language. This is more pronounced where due to specific pronunciations, habit or style, there can be different spelling for some name in different languages by English Swensu. The appellant had produced the documents showing that his father, mother, Swensu. The overall discussion of the report, opinion, tribunal Swensu, the appellant's documents, however, their authenticity is not in doubt. In the considered opinion of this court, the same would further buttress the appellant's claim that not being in the wrong and being an ignorant person, he thoughtfully and faithfully produced the official records as they were in his possession. We do not see any attempt by the appellant to get his official record prepared meticulously without any discrepancy. The conduct of an illegal migrant would not be so casual. The debate has long been settled. The penal status must be constituted strictly. Tolaram Swensu. The question that needs our determination in such a situation is whether Section 8 makes punishable receipt of money at the moment of time when the lessee had not come into existence and when there is a there was a possibility that the contemplated lease might never come into existence, it may be here observed that the provisions of section 22 or penal. Yes.
Construction of penal
Yes.
statutes.
Now, illogical, my friend says, in that particular case, may not be there's a record. The Supreme Court found record, and on the basis of record, there's a name, moment thing, it is there. They produced the record, they have found the inquiry report. On the basis of that inquiry report, that observation has been given. Now, illogically,
So how do you reconcile the argument made that the relevant discussion by a larger bench in the case of Sarvananda one have not been taken into consideration?
Sarvananda Sunal case has not been debated here. It has been discussed.
No,
They-
those
they-
paragraphs-
They only say that Sarvananda Sunal case direction has not been complied with by the authority.
No,
Direction
the paragraphs which have been discussed
is a
here
42 and
are not the paragraphs which Mr.
42 and.
Pang has pointed out
Yes,
now.
yes.
55 has been discussed.
Yes, it should not be given.
Yes.
That was. But so far,
So if the same procedure, we have to go back.
No.
Won't it amount to again reviving
so far is section.
act which has been declared ultra vires?
No, we are not. We are our decision not on that. Our decision only they should follow the section 3.1. The section 3.1 has not been followed. That has been clearly discussed. They should follow the section 3.1. Why they are not furnish the grounds? Why? Inquiry report. Why? We are not any particulars, but they should.
Section
The-
2 has doesn't provide that the inquiry report has to be furnished.
Not inquiry grounds. Grounds mean
Ground-
what?
the
What is
ground
the
is
ground?
property notice
What is
itself.
the
That's why it's
opinion? What is
submitted.
the suspicion?
Please
Those
read,
are-
section order 3.
Order 3. Order 3
That the
provides.
tribunal shall serve on the person to whom the question relates a copy of the main grounds, my lord, on which he is alleged to be a foreigner. Notice only disclose suspicion. Whether it is a ground, my lord, there should be a ground. This is not there. That has not, this
As per you, what would be a ground
ground
which can be disclosed?
where they got information that I am a foreigner, what is the materials, whether they have taken any evidence by making, before making, they are making on during that time making inquiry, they have taken.
See, the notice is preceded by an inquiry. If the notice is not preceded by an inquiry, you may have a case.
Hmm.
Now, if the record shows that an inquiry was done, whereafter the notice was issued, can you say that it's without any ground?
We are only confined our argument that grounds should be furnished. Notice indicated there is no grounds.
Notice may be seen, my lord. Notice is there. Notice is not annexed.
We can see whether this is there. Isn't it there?
Especially this issue, my lord, whether notice should contain the grounds or not, and what,
My lord,
what amounts to, my lord, grounds. In this aspect, my this honorable court dealt with extensively on that issue. It is, my lord, may submit this judgment. This is 3805/2016 and
Name,
disposed of on 8/3/2018, my lord.
name,
Name, my lord, Dukumia.
Okay.
Dukumia. DUKSU Dukumia.
DUKHU
MIAH.
versus Union of India.
Here, my lord.
Versus Union of India. Versus Union of India.
Versus Union of India.
And please give the number again.
3805/2016, madam.
The date of the judgment.
Date 8/3/2018, madam.
Okay.
Especially this issue was taken care of, madam.
Which para?
Para 21, my lord. Para 19, 20, 21. 21 relying the earlier judgment of this honorable court, my lord, that quotation may be seen, my lord.
Yes.
Para 21, the quotation part and the last part. Firstly, a notice is given to the notice in Maker proceeding. The notice.
Have you given a copy?
Sorry, my lord, I don't have it.
So if you are saying para 21, we do not know what
Yes,
you are reading.
your lordship.
You can read there, but
Yes, I can read the appropriate paragraphs. As pointed out, my lord, the last part of the first para of the quotation, my lord.
Yes.
As pointed out above, the grounds can be, my lord, the use of expression copy of main ground as apprehended in clause 3(1) should be understood to mean disclosure of the grounds in the show cause notice. As pointed out above, the grounds can be incorporated in the show cause notice itself, as those need not be elaborate. After all, the objects of issuing notice to inform the noticee beforehand about registration of the proceeding, reverting to the facts of the present case, it is already been noticed that in the show cause notice, it was mentioned that as per reference of the Superintendent of Police, Bongaigaon petitioner was suspected to be foreigner having illegally entered into India, Assam from East Pakistan or Bangladesh, whether his reference was registered. Whereafter his reference was registered. This itself is the ground for issuance of show cause. That is the ground, madam. That exactly that is mentioned in the notice, madam. My lord, here the issue is not nothing more than that. Secondly, it is also said, it is evident that no prejudice has been caused to the petitioner by alleging non-furnishing of copy of the grounds. What prejudice will occur? It is their duty to prove that I am not a citizen foreigner by bringing reliable documents. That must only. What prejudice occur? We are not saying that bring this document, you don't have this document, you don't have this book. Bring your reliable documents, whatever documents you need, file a presentation. Get your, that must only matter. We are not saying that you have to prove that you are not coming from East Pakistan of this village. We are not saying that. We are asking them only, let you prove that you are a citizen of India by reliable documents or any evidence. That must only. And further, my lord, I'd like to submit only one point, my lord. All these things were discussed rightly or wrongly, my lord. The tribunal has taken a view. Tribunal has passed an opinion on the basis of materials available on record. Now, can this honorable court under certiorari jurisdiction and alter the decision if there is no violation of principle of natural justice, if there is no error apparent on the face of the record, my lord, if the my lord, tribunal has not considered the my lord, evidence which were not which were placed before the tribunal, there is no such question of my lord. They are saying that the appreciation of by the tribunal is wrong. They should not have appreciated this way, that way. That is not the way. My lord, this is not in the this is under certiorari jurisdiction. They cannot do that. If the tribunal has violated any provisions of my lord, any principle of natural justice, then it's okay. If tribunal has not considered the evidence which were my lord, which were submitted by him, which were reliable, in that case it is not there. This, my lord, your lordship knows, my lord, this is 2023 SEC online SC 996.
Bickerton.
Yes, my lord. Central Council of Research, my lord.
Bickerton does.
Yes, Bickerton does. Para 50 onwards, my lord, it is the proposition has given under what circumstances this honorable court may, my lord, interfere under statutory jurisdiction. That may be considered.
Okay, we'll reserve this.
Okay, my lord, paragraph 49 of my judgment, decision judgment, this Somananda Sonal case has been discussed. Will also can you see paragraph 49?
Yes.
Section 5. There cannot, however, be any doubt whatsoever that adequate care should be taken to see that no genuine citizen of India is thrown out of the country. A person who claims himself to be an Indian citizen in terms of Constitution of India or Citizen Act is entitled to all safeguard, both substantive and procedural, provided for herein to show that he is a citizen. Status of a person, however, is determined according to status. The Evidence Act of our country has made provisions as regard burden of proof. A different statute also laid down as to how and in what manner burden is to be discharged. Even some penal statutes contain provisions that burden of proofs shall be on the accused. Only because burden of proof under certain situation is placed on the accused, them said would mean that he is deprived of procedural safeguard. So when the Sonal gets discussed. Hello. Now, my friend.
This is the servant under two.
Two. Two.
He is
Sarvanta
relying
Sonal,
upon servant the one where IMDT
Yes,
was
I-
declared ultra vires.
Yes, my lord. Paragraph, my friend, read paragraph 42 and
Yes.
44 of the Sarvanta one.
Yes.
Sarvanta one, I gone through it, my lord, now. I have gone through it. ये तो ना एक है 44 44 so my lord it will get on the let's one. Paragraph 42 and 44, I have gone through it, my lord. You will also kindly see the paragraph 42, what is reiterated. It is elementary that a person who has illegally come from Bangladesh to India and is residing here for his better economic prospects or employment would never disclose that he is come from Bangladesh, but would assert that he is an Indian national and reside in India. There is no question of his telling his date of entry or giving any information on the opposite points. According to Rule 7 and 8 of rules, the inquiry officer has to submit report in form so in form so lays down that an application to the tribunal under section 82 shall be made in form 3. An application to the central government under section so shall be made in form 5. And the declaration under section shall be made in form so. Curiously enough, column 6 of form requires the applicants to to furnish the following information regarding the illegal, whether intercensorship. This is a question, those are the question. They should come before me, put question, then we'll disclose. Whether they come before me, my lord, they approach me. You give the information, give the evidence, whether you are citizen of India. So that family is not a,
You
that,
cannot, you are going back 15, 20
No,
years back.
no, my lord.
Those have been settled. Those have been settled. Those are meaningless arguments.
Suppose
Those arguments made, answered. We are not going to again entertain this kind of
inquiry, people inquiry sitting in the office. Get
The
it acceptable, my
procedure
lord.
has been laid down. You argue on your case. Cannot go back what has been settled.
No, my lord. So this is heaven actually.
Yes, okay.
So my lord.
Please, the proof. Yeah, no. Yeah, fine. Control.
There is an order on 26/8, my lord, by which one, my lord, the record in respect of the Diffu PS case number 011/2017 was called for. And my lord, the direction has given to deposit, my lord, 1 lakh. My lord, that was accuracy and it has been issued by the Human Rights Commission, my lord, the Nagaland government in favor of the petitioners to be handed over to court.
How much it was, just a second, I have to check. I have to keep.
You have got the report.
My lord, the report, I have the draft of 1 lakh, which has been directed to be.
No, that's a different, on the report.
Scan.
No, actually, that's why the
report is
direction-
to be
Wait.
transmitted to registry.
Registry, madam.
Has it come?
I think it is not there. I have checked it.
It has not come.
What is it?
3/9, it was given, a copy was also given to you, madam.
My lord, we have communicated to them.
Direction was to directly to registry to obtain, my lord. This is where the order. in para number 3 and 4 of the order, last order.
Report of an accommodation, check on the LBD body. No, the looks too good. Too last one. There is 2,000 group into the different. It was conveyed by you, madam?
My lord,
It was
we have,
conveyed.
we have
Okay.
conveyed the message, the check amount of 1 lakh is also here with us.
You would like to receive the check?
The lady has come, and she will be, I'll give it to her.
Okay, you
Has she come?
will hand it over to the council?
I
It is
can,
a, what kind of check is this?
This is
it
Banker
is
check?
1 lakh rupees, that is
1
in
lakh.
Banker check or what?
No,
is
it's
in
not
draft, I
a
think.
check, it's a draft.
Pay order,
yes, it's a pay.
pay order or a banker check?
But it is a check,
It's a check. No,
a check,
Let us have a look.
it's a check.
this is a check.
This is a normal check, current account.
Account pay check.
Yes, yes. It's not, it's a current account check. It has to be an account pay only. Cannot withdraw cash. Heard Sri P. Fukan, P. Mahanta, learned counsel for the petition. Also heard Miss A. Iyer, learned additional senior government advocate, Nagaland. Full stop. Para. Perused the office note dated 3/9/2025, as per which copy of the order of the court was communicated to the learned judicial magistrate Dimapur and to the superintendent of police Dimapur. Full stop. It however appears that the scanned copies of the case records of the FUPAR PS case number 01117 are yet to be received. Full stop. The learned State Council Nagaland has also informed this court that the concerned authorities were informed about the order in question. Para. The State Council has also informed that in terms of the said order, a check bearing number 099626 of the State Bank of India, Nagaland Secretariat Branch for rupees 1 lakh in the name of the petitioner has been furnished to her for onward for making the payments in terms of the said order. Full stop. Let the said check be furnished to Sri P. Mohanta, learned counsel for the petitioner, who undertakes to furnish the same to the petitioner. Para. List this case after 2 weeks to enable the receipt of the scanned copies of the case records as per the earlier order.
Master.
A photocopy of the check is kept with the records. Do the copy documents. You keep 1 copy with yourself also, madam.
My lord.
Master.
Yes.
May it pleases your lordships. My lord, impugn order is at page number 35. Impugn order dated 34/20/22, lordship.
35.
Yes, lordship. So petitioner has contested the matter. She has exhibited one registered sale deed of her father, registered sale deed, lordship, at page 78 of her father, and subsequently this same land is being mutated, and the registered sale deed of dated, lordship, dated 8/2/71, lordship.
Eight to,
71,
what is it?
1971 sale deed, registered sale deed. This is the only document, old document she has exhibited as Exhibit A, lordship,
Sale deed in favor of?
in favor of her father. Her father has purchased that land.
Name of the father?
So, Abdul Subhan, lordship.
Yes.
And subsequently, the same land is being mutated in the name of her father. And subsequently, after the death of the father of the proceedee, the petitioner, it is being mutated in the name of her other siblings as well as along with her name, lordship.
Yes.
Her father name was mutated. The relevant portion is at page 93, lordship.
'93.
Page 93. Serial 17 is Abdul Suvan Amjad Ali. He has purchased in the year 1971 by order dated 29/10/75. This land is mutated in his name, Khoriddari Hutre.
Where is your name?
Abdul Suban, just below lordship. 1, 2, 3, 4, 5, 6, 7th line, Chitar. So
72.
that order date is 29/10/75, Ingraji Tarik Mote, Khoriddari Hutre.
Now, this is insertion of the name of the father. Or
Father, yes. Then
But-
subsequently I'm coming.
Now, why is his name then struck off?
Because he died, so his name struck off, and their name means the petitioner along with the other siblings' name came in.
So when did you take this out?
Yes, lordship.
This is after his death,
Yes.
because since it is struck off. it
Yes,
means-
lordship, after his death. But when his name was inserted, it's way back in the year 1975.
On the remark column, or where are you? Number?
Page 95, lordship. উত্তৰাধিকাৰী সূত্ৰে আব্দুল সুবানৰ স্থলত মইনাল হক, পিতৃ মৃত আব্দুল সুবান, আৰু সুফিয়া খাতুন, পিতৃ মৃত আব্দুল সুবান, and rest are, and Moinal Haq has adduced evidence as DW2. And Lordship, all the dark numbers are also mentioned in the sale deed, in the schedule of the land. The dark numbers mentioned in page 92.
What else, madam?
Yes, and this is the only vital document she has exhibited before the learned tribunal. And she has exhibited voters list of 1985 of her parents, 1989 of her parents. And another linkage certificate is Gambura certificate.
Your voter list?
She is marked as D voter, Lordship, since 1997.
Let us see that. Where is it?
Lordship, the LBO's report reveals that, but she has not submitted any document that she has those voters lists specifically, Lordship. No voter list was annexed. Her voters list was not annexed before the learned tribunal.
And regarding your father, Abdul Subhan, what have you given?
The sale deed,
No,
Lordship,
sale deed.
apart from sale deed,
Yes.
1985 voters list,
Where page?
page 82, Lordship. Abdul Subhan. That's serial number 47, Lordship. And page 83. Page 83 is of her mother, stepmother, because he died in the year 1986, where she has stated in her written statement that my father died in the year 1986. And she herself has adduced evidence as DW1.
Okay, we'll come back. Which item? We'll have it sometime later. A 6 on report under 6. Peacefully, one of mention made by service list on certain. Yes. Huh? After a week. 1 week. Yes, madam.
And the big document with my father is the Jamabandi as well as Gambura certificate. Gambura certificate is a page 56. And Gambura also has a new evidence as W3. and brother of the petitioner has used evidence as TW.
Let us see the evidence. This, this certificate is dated 7/11/19. Certificate of the Gaonpura is 7/11/19. After the FT case was initiated.
They need to get the certificate. These are the poor people, they don't go to school. And whenever it's relevant, they take out the certificate. Not that only because of the case, but that was at that time maybe advised by the council to take out the certificate as it is.
Yes, where is the, where are the evidence?
Evidence in the page 52 is the sense of the.
Yes, please.
Resident of village Gorai, PS Barpeta Road, District Barpeta, Assam. So I am a citizen of India by birth and a permanent resident of the said locality. Yet I am a citizen of India and a housewife by birth. But the superintendent of police borders referred the case suspecting me as a foreigner of post 65 pre-1971. The case is therefore without fair investigation behind the back of me. Therefore, the question of producing documents before the investigating officer does not arise and as such, this reference illegal copy as such, the proceeding to bear in law and license to the district for the I beg to state that my age is your age is not mentioned, but above it is mentioned. 39 years, and the evidence was filed on 19/2/2020. And born and brought up at a village, Akaliapada, Moja Village, yes, Barpeta, now Howdy, district, Barpeta, Assam. And after the age of majority, I was got married to one Sattarani Mandal, son of Telugu Mandal of village Garaimadi. My father's name is late Abdul Subhan and my mother's name is Moina Kavi. My father was dying in the year 1998. Actually, the 6 is missing, but in the WS, this is there, 1986. But here it is missing, and even in the order also, her father died in 1956. That is mentioned in the order because it is in her plating story. In the WS is mentioned. 46 in her subsequent lordship. Yes, her father was died in the year 1986. In page 46 is mentioned, but here in the evidence 6 is. Page 46, first paragraph, 3 lordship. Mentioned. And my grandparents' name is late Amjad Ali, who died long back. I further beg to state that my father were two brothers, namely Abdul Majid and Abdul Subhan, and one sister, namely Surya Gandhi. The opposite party has one brother, namely Mandal Haq, and four sisters, including the opposite party, namely Sufia Khatun, Sarifon Nessa.
Anywhere, voters list with your father, of your father, mother,
Yes, together.
where, no, where are the voters list?
Voters list is that page, 85 is that page 52.
82.
Abdul Majid. And Abdul Subhan. Her father died in 86, so 89, her father's name is not there, but her mother's name is there.
Age?
Page 83 lost it.
And who are this Rausanwara and Jarina?
Abdul Majid is the uncle's wife. Roshana is there in 85 also, Roshana.
85.
Page 81 of. Account for us. The age difference is too vast for the uncle and the aunt. Have you noticed? In a span of 4 years, Abdul Majid becomes 54 from 36. And Rosan Begum becomes 48 from 31. Abdul Subhan and Moina remain the same. Moina remains the same. 26 to 30 is okay. But then in 81, Moina is the wife of Kuddus Subhan.
এখন আমরা তো প্রথম পেজ 82 এটা হলো ফিনিশন withdraw ওপর অন্তর্ভুক্ত করুন 1 নম্বর কমে 2 নম্বর ঘর 2 নম্বর টানে 154 ঘর ঘরটা নেক্সট টু এটা লোয়ার হলো তার নাম এটা নেক্সট পেজ টু হলো হাউস নাম্বার হলো তো 183 within a span of 4 years. Or to part 47, it will part 42 to on the over.
ভকলিয়া পাড়াটো মিলি আছে
Earlier, part to her, DW2 contact বুলি কৈছে DW2 sister বুলি কৈছে এটা sister কৈছে এইকেইটা নামে নিমিলে I have 4 sisters. Sufia Khatun, Sufia Begum Bolush. Sabira Nisa, Sabia Khatun, Sajida, or Safida, Sahida. At a long episode, White father has 4 statements. A statement to whom? Which is father, 2 brothers. I'll step over from a problem. He's the water one, he's the brother of others. Papa from you. Yes.
Although we have not got opportunities to do it, I would like to place reliance upon section 90 of the Evidence Act. And also reliance upon our honorable High order worship. Presumption may take on as per section. And with that regard, our High Court's order GLT 22, 4 GLT 426.
Two thousand 20. Name?
Decided on 23/6.
What is there?
May I read section 90 first question?
Yes, please.
Presumption as to documents 30 years old, where any document purporting to be 30 years old is produced from any custody which the court in the particular case considered proper. The court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting, and in the case of a document executed or attested, that it was duly executed and attested by the person by whom it purports to be executed and attested. Explanation: documents are said to be in proper custody if they are in the place in which and under the care of the person with whom they naturally be. But no custody is improper if it is proved to have had a legitimate origin, or if the circumstances of the particular case are such as to render such an origin probable. So, she is the daughter of so and so. So her brother also has deduced evidence as legal. So it was in the custody of the brother. So she brought her from her brother and she has exhibited. And she is daughter of Subhan, Abdul Subhan, and she has exhibited that sale deed with through which her father has purchased the land way back in the year 8/2/1971. And which are this order also, which I have stated, Lordship, 2024 PLP 426. Paragraph 33, 34.
Yes. Exhibit A was in the, what form it was reduced? Certificate copy was reduced. Are you sure? Page 37. 37. There is no original in the record. 37. Photocopy of certificate.
The photocopy of the certified copy of the same.
Photocopy will have an evidentiary value. No, might have been, will not do. We have seen the records. The original was not there. No, this would have been reflected here.
Sometimes this is but sometimes the lawyer has to like compare with the original.
We're trying to ascertain that.
But my husband's will be the matter is remanded back. Before the learned tribunal also. Because the exhibited document, the Jamabandi, that also was not. If the authorization is not been consort as like.
It was all received by the কি হবে বা তহিদুল টু কোন দিয়ে নাকি দাদা ইংলো এটা বেলেগ হ্যাঁ এই তহিদ নহয় এটা সফিয়া হ্যাঁ সফিয়া है जो তাই হিকম একিরি হিকম itu cross itu ini cross उसको कंटिन्यू लेवल पे जाने के लिए exhibit and here the field did the field did
How many wives the father had?
Two.
Two wives.
Yes.
Her father had two wives.
Our mother died when she was very young. In her cross, she has stated all this. And our mother's name also she has stated in her cross. But she was being brought up by the stepmother, Moina.
Names of the sisters also don't match in the written statement and in the evidence given. Page 46. Compare page 46, the names that have been given, and page 53. Okay. No, read page 53. That was the evidence. That is part of the evidence. The third paragraph from the top.
Yes, sir.
Yes. Moinal Haq is the brother.
Yes, sir.
Sufia, Safiron, Khatun. Then come to page 46. This Safiron goes missing. Page 46, same place.
Page 46.
Same place. Sabia, it becomes Sabia. Safiron becomes Sabia. Nessa goes. Then if you come to the cross of the DW2, again he gives another name, Sabiran. Then again at page 46, he says that her mother's name is Moina Khatun. She does not say that she is the stepdaughter.
She did not say it in her.
She's the mother. So there was no reference to any stepdaughter, any stepmother at any point of time.
He died. He was being brought up by the stepfather. That's the document she has seen. Her mother died. What is the document? The evidence.
The cross. My mother's name is Haju Khatun. And I have stepmother, namely Moina Khatun.
Yes, what else, madam?
Stated now, but in our cost will state that regard, I'd like to rely upon our disorder. 2021 CGFP.
Paragraph?
Paragraph 20, 20,
20, 22, 24.
And Lordship, moreover, here, while going through the reference, there is no allegation that she is from the specified territory, Lordship. There is no allegation. And in fact,
Now,
Lordship,
what has been stated in Hyder Ali? Don't finish
Yes.
off with Hyder Ali. What has been stated in those paragraphs?
may I read the paragraph 20, Lordship? The fact in issue required to be considered by the tribunal was whether Harmuz Ali was the father of the petitioner and Hawa Khatun his mother, and in turn whether Nandu Mia and Aimona Nessa were parents of Harmuz Ali, who undisputedly were all Indian citizens. The voters list of 1965 shows that the name of Nandumia and Aimana Nessa are included, who the petitioner claims to be his grandparents, thereby showing that they were Indian citizens. The name of Harmuz Ali, the father of the petitioner, is also shown along with his father as Nandu. Under the voters list of 1971 shows the relationship under the house number 61, same village, Moja, so-and-so, part number so-and-so, same subdivision of Borbet. It appears that the voters list of 1971, in which the name of the petitioner's father, Harmuz Ali, is shown along with his father, Nandu, was not exhibited before the tribunal. However, on comparing the same, we have noted that all the particulars are also same, with the house number, name of the village, name of the Moja subdivision, etc. Though this court would not normally entertain any fresh documents which was not produced before the tribunal, we, for our own satisfaction, compare the certified copy of the voters list of so-and-so annexed in this petition with the voters list of 1970 on record. Since the authenticity of the certified copy of the voters list of 1971 annexed in the petition has not been controverted, we have considered the same. It may be noted, it may also noted that there are other documents which have been relied upon by the petitioner, as we shall see later, sufficiently corroborated the claim of the petitioner. Thus, the fact that Harmuz Ali is the son of Nandu Mia is clearly established by this voters list, so-and-so, so-and-so, and so-and-so. Then it may be also seen that the state never questioned the authenticity or genuineness of the voters list of so-and-so and so-and-so before the tribunal. Thus, this document had remained unrebutted. So in my case, there is no objection with regard to that, that I have exhibited. Exhibit A is the sale deed, registered sale deed, which I have exhibited. There was no objection to it, so that there was no rebuttal to it. And moreover, it's more than a 30 years old document, so I relied
No,
upon.
the document as such may be admissible. What about the contents? We are not on the documents, we are on the contents part.
There was no objection also, Lordship.
Objection with regard to the document.
Yes, Lordship.
Document is admissible in evidence. 30 years. We have also seen, let us give you the benefit of doubt that the original was given. taken
Yes,
back.
Lordship. Yes,
Those
Lordship.
are there. But we go by the contents. What does it prove? It proves that one Subhan had purchased certain land
Yes,
in
Lordship.
1971.
Yes, Lordship.
We are now interested to know what is your connection with Subhan.
Yes, Lordship. Then the Jamabandi, Lordship. I would like to.
Yes.
Jamabandi, in that same Jamabandi, Lordship, this is the reason my humble prayer was that if this honorable court pleases, that if this matter is remanded back to the tribunal so that she can prove the Jamabandi. In that same Jamabandi,
What
Lordship,
prevented you from proving the Jamabandi?
that right now I
There-
can't.
there-
Yes, Lordship.
There will be difficult questions to answer.
Yes,
And
Lordship.
there is a discussion also in
Yes,
Impugn-
Lordship, yes,
impugn
Lordship,
judgment.
that I do admit. This is the reason my humble prayer is that, Lordship, if it's remanded back to the tribunal, then she can prove that document, Lordship. Even Sarbananda Sonowal 2, paragraph 55 says that no
you have-
genuine
you have
citizen.
proved that Jamabandi is exhibit B.
Yes, but no authorities were called for to prove the contents of that document, Lordship.
But
Exhibit
that Jamabandi was done when?
Jamabandi, her father was mutated at Khoridari Hutre in the year 1975.
No, the Jamabandi.
19, Lordship 19, 2019. That I have shown in the last page, Lordship. Last page of the writ petition, page 95, Lordship.
Why don't you have any voter list?
I have inquired, Lordship. Then uncle's name is there in 70, they said.
No, you
But
have
that
voter list. What is your age now?
her age is 45 years,
45
Lordship.
years.
Yes, Lordship.
So
97, her name was inserted, and then
your date of birth will be somehow around 1980.
80, 80, Lordship.
1980.
Yes, Lordship.
So by around
The
2021 or 2001,
yes.
at that time it has become 18, I think. Let's
89, it became 18 years.
Yes.
So in 97,
97. You
Yes.
don't have a voters list.
97, she would have been 17. Yes, 18.
97, then
There's the reason. From there onwards, she was marked as D.
even their voter list is not before us.
Yes, Lordship. Lordship, if Lordship pleases, may I submit one and seeking Lordship's indulgence, if I can get those D voters list and I can place before this honorable court. She is
Yes.
marked as D voter, that
You have to
is.
discharge your burden before the tribunal. That was the purpose of the
Yes,
reference.
Lordship, definitely, Lordship, that I understand. But sometimes when that is not there, she has approached this honorable court, since the appellate provision also is not there in the law, Lordship. So where these people will go, Lordship. So, and it's a devoter case that it reflects because it's a ERO's forwarding this thing. And even the inquiry from this annexure A, Lordship, LBO's report, there is no allegation that she is from the specified territory. Then that allegation, if she has not given any documents, then it was easy for the LBO to put in that she is from the specified territory. But there is no allegation that she is from the specified territory, Lordship. And even with that regard also, I would like to rely upon Anjana Biswas versus Union of India, Lordship, wherein even the entire LBO's report was being scanned of that particular case and is being reflected in the in this order, Lordship. 2023 2 GLT 110 1120, Lordship.
One?
1102.
1102. Name?
Yes, sorry, Lordship. It's Anjana Biswas versus Union of India and others.
What is there?
That is with regard to that specific allegation. It starts from paragraph 55, Lordship. In the verification report as available in the original record, the relevant facts have been mentioned. To understand this properly, the scanned copy of the verification officer's report is reproduced herein below. Then paragraph 56, Lordship. Perusal of the aforesaid verification officer's report clearly indicates that the inquiry officer had noted at serial number 5 of the form that the place of birth of the petitioner is West Bengal. It has been further noted that at serial number 13 of the form relating to inquiry officer assessment on the dialect spoken, it is specifically mentioned that her father resides at Calcutta. So she was unable to provide documents within sufficient time. As can be seen in respect of other entries required to be made, these have been left unfilled. Paragraph 57, in this regard, one may refer to serial number 15, which relates to information as to whether migrated into Assam, with the remark yes, no, but nothing is mentioned under that head. Similarly, in the subsequent serial number 16, as regard the column, if yes, one, place from where migrated, it is again kept unfilled. Similarly, in respect of serial number 16-2, whether migrated A before 1/1/1966, B between 1/1/1966 and 24/3/1971, and C on or after 25/3/1971. The same has been also kept unfilled. However, on the basis of the said verification officer's report, which does not indicate at all that the petitioner is an illegal immigrant but hails from West Bengal, the ERO made the observation that he had reasonable doubt that the proceedee is not a citizen of India, and accordingly forwarded the matter to the Superintendent of Police, Border, Morrigaon. The scanned copy of the said finding of the ERO dated so and so is reproduced herein below. 59. We, however, fail to understand how the ERO came to such a conclusion when it is specifically mentioned in the verification officer's report that the place of birth of the petitioner is West Bengal and her father reside at Calcutta, because of which she was unable to provide documents within sufficient time. The said reference was made based on the verification report of the LBO as mentioned therein. The said report of the verification officer is dated 10/9/97. And I think, Lordship, there is no date mentioned even in this reference. There is no date mentioned. Date and place of the local verification officer's report, that is missing, Lordship. No date, place. Page 75, I have annexed. And even the original records are here. Entire form. And even this inquiry form,
Yes.
so this entire form is blank, Lordship. And this also, in this case also, it's relied upon the Indira Nawaz judgment of our Honorable High Court, as well as Sonakha, which is in the judgment in that particular order, those, and I would also like to rely upon Sonakha, which is 2021-3 GLT 12, Lordship, and which is also mentioned while arguing this case. These cases were also being referred while arguing Anjana Biswas. Sonakha is, Lordship, 2021 3 GLT 12, Lordship. 2020. Wherein also reference
Yes, okay.
paragraph, Lordship, of Sonaka, Lordship, paragraph 8, 10, Lordship. And 11, Lordship.
18, 11.
Yes, Lordship. And also I would like to rely upon Rahim Ali, Lordship.
What purpose?
Basically on this investigation and paragraph 34.
Rahim Ali, we have just discussed, you were in the court, that the part of paragraph 42 of Surrender 1 has not been taken into consideration.
And moreover, Lordship, Sarvananda Sonwal 2, paragraph 55, it says that a genuine
Yes,
citizen.
yes,
That this is the reason my humble prayer, yes,
No,
her case was not
that is-
properly being established before the
that is
learned
of paramount
tribunal.
importance. No,
And this is the
none of
reason-
the citizens should be harassed or even a proceeding should be initiated. That is of paramount importance. There is no second opinion about this.
This is the reason there are loopholes, definitely, Lordship, on the part of the petitioner to establish her case before the learned tribunal. So my humble submission is, if the matter is remanded back, and if she would have been given a chance, Lordship, if she would have been advised well, Lordship, more documents would have been placed before the learned tribunal, Lordship. And due to financial scarcity that I have stated also in the writ petition paragraph 33, she could not even approach the honorable court within a reasonable time. There was delay in approaching. So my-
Yes, Mr. Bang.
My lord, your lordship may kindly see the contradiction which I'd like to point out for the two contradiction your lordship may kindly see. As your lordship has pointed out, page 46, my lord. That is the WS. It is my settled position of law. What he has pleaded in the WS, that has to be proved by mother bringing evidence. They cannot go beyond the pleadings, what is there in the mother WS. That means what is there in the WS. Now, pleaded case is that, my lord, there are three, my lord. It's clear. As the lordship has already, mother created the WS. He has nowhere stated that he has kind of stepmother. That issue was nowhere in this WS. When cross-examined, this issue has come. This sending of statement, had there been my stepmother, she could have stated all these things in the WS.
How does the stepmother make a difference, relevance?
No, my lord, why? My lord, may kindly see. Here her statement is totally, my lord.
Not mentioned.
Yes. WS is mentioned. My lord, para 3, the opposite.
We have read.
Para 3 is, page 56, the age is not mentioned, it's totally vague. Then what I'm on, my lord.
Age of?
Age of the petitioner, the opposite party begs to state that her age is so and so, that is blank. So and so years. That is blank, page 46, man. It is not mentioned. Supporting affidavit, it is, yes, but here it is not mentioned. Born and brought up, village so and so. When born and brought up, that is nowhere mentioned. First of all, here the first issue is as per Sobananda Sunwal 1.
Now, what is not there, born and brought up at village so and so? Yes.
Yes, no date of year, man. No date, no year. When did born? What is the requirement of law as per Sobananda Sunwal? He has to establish only 5 things. The date of birth, place of birth. Para 26, Sobananda Sunwal 1. Date of birth, place of birth, citizenship of his parents, if necessary, citizenship of his grandparents. Then he has to bring evidence on that. And if necessary, state can rebut it. That is the simple point. They have to bring evidence to prove all these facts. Date of birth is of the petitioner, place of birth, unless you get parent citizenship, if necessary, grandparent citizenship. Then, after bringing evidence, if necessary, the tribunal, the court, the state may rebut. That is the only point. Now, everything is back here in paragraph 3. She has said she was born in date of, I'm not saying date, at least year. I was born on this year, probably during this period. That is also not there. What there is, after the age of majority, she was married to one so and so. When it was, when she got majority, she got married after getting majority. Village so and so, so and so, so and so, and got married to one so and so. Procedural so and so, so and so of so and so village. Her father name is that Abdul Saban. This is positive assertion, my love. Her father name is Abdul Saban, and mother's name is Moina Khatun. This is positive. There is no any other view. My father was died in 1986, and her grandfather led Amjad Ali, who died long back. Long back is not, it's totally back. When long back, you cannot see. The opposite party father begs to state that her father has 2 brothers, namely so and so, so and so. 2 brothers, madam. Father OP number 1, and namely Surya Bhanu. Sister name is Surya Bhanu. Then opposite party 1 brother's name Moinul Haq, and 4 sisters, including the opposite party's name Sufia Begum, as your lordship has pointed out, this Sabia Khatun, Sajida Khatun Elias, and Saida. Now, your lordship may kindly see the evidence part at page 52. Your lordship has seen already. Even thereafter, here also he has not corrected that wrong. He has just copied pasted further. I beg to state that my age is blank. So
50?
Page 53. This is evidence of the mother. Same thing. After the age of majority, I got married when it is not there. My father name is so and so. It is affirmed. My mother name is so and so. That is Moina Khatun. That is also affirmed here. Evidence also she has not said. She has a mother who died because, my lord, if we see the age discrepancy, that's why to fill up this age discrepancies, my lord, they're bringing this. This is then every time your lordship will find, then your lordship also have seen the sister name is changed in, my lord, they are in Safiron Nesa. This has come into play. Earlier it was not Safiron Nesa, it was some Sabia Khatun was sister. Now Safiron Nesa in evidence. Now in cross, my lord. Cross part, this is totally a different story now. Page 57. This is totally a different story. This has come out in cross ones. Page 57 is the cross one. I was born in.
Just a minute, please. She has taken the pain to correct one of the names of the sisters
Yes,
in the
Evidence.
WS and evidence.
evidence.
WS four sisters were Sufia,
Yes,
that is the opposite party,
yes.
Sabia. Sabia becomes what? Safiran.
Sabia became Sapura.
Safiran. Safiran.
Safiran.
Safiran. Then-
Sabia Khatun become others, others are correct.
Others.
Tahida,
Tahida.
Tahida.
In
And-
spite of cut paste, there is one change.
No sense.
And let us see the cross.
Cross page 57 minus. This is needs to be come out. Not when cross exam. I was born at village, page 57 minus. My name is Safia Khatun. I do not know my age.
57.
57. I do not know my age, my lord. I don't know what it is.
Yes, it's written that only.
Yes. I do not know my age.
Gaon isn't fair here.
Now, my lord, I was born in village Dakhadia Para. My father name is Abdul Saben. At that time, I was 5 years old. What time, my lord, I do not. My father died at village change. So probably when father died,
Right.
she was 5 years old. Now, our family had shifted to village Basbari, Bagan, as my father had purchased land at Sencho. It is situated presently under Baksa district. My mother name is Haju Khatun. Here mother is Haju Khatun. Everywhere she was disposed in my lord, stating that Amina Moina Khatun. Then when it question comes, I have stepmother's Moina Khatun. Now Moina Khatun becomes stepmother. My own mother died while I was kid. My grandfather's name is Amjad Ali. I did not see him. So, mother says, I'm this, whom she was projecting as her mother, Moina Khatun, she become mother, stepmother. This is not disclosed anywhere. While cross-examining, this is come. This is the big contradiction now. Now, when you know things like that, is in what aspect more? DW proof the projected brother. Witness brother.
Read page. Still read on page 78 at the side. Assist করে দিল তুমি পড়াবে আমি assist করে দিলে পড়াবে
এইটো ই নহয় এছে হয় বাৰু বাবিয়া খাতুনটো নাছিলে খাতুনটো সোমাই দিলে Yes.
Only I would like, so one more thing, you also kindly see the other evidence of W proof. Once the petitioner projecting first as to be mother brother. Page 61, only one line I'd like to know.
61.
Yes. In fact, all this thing has been discussed in the tribunal by the learned system.
61, come to the handwritten portion.
Harnikulam,
Say handwritten
page
portion,
63, man.
handwritten portion,
Yes.
DW2.
W two. Page 30.
Moinal.
Minal. Minal pop. Abdul Shokri. I am the.
I have to depose
I'm
for PO.
Ofi, who is my elder sister. I do not.
No,
I do not,
I
her
do not-
age,
I do not.
I
her
do
age,
not know age.
no is
Her
not.
age, madam. It should be her age. I do not her age. I know is left.
She was given
She was
marriage.
given marriage on to one namely Shoicho Sattar Ali
Mondal.
Mandal of village. Shoicho. She has 5 children, 4 sons and daughter.
One
My-
daughter.
Yes, one daughter. My father had 4 step brothers. This point has to be noted. Madam. We are 5 brothers and sisters. My father had 4 step brothers, my love. This was not here. She has said in her statement, her father has 2 brothers, 1 brother and sister. Your lordship will find. Page 56, madam. Page 56, your lordship, go back. Second paragraph. Paragraph 3 in the second paragraph. The opposite party further begs to state that her father has 2 brothers, namely Abdul Mujib and Abdul Salam. Abdul Salam, brother himself, and 1 sister, namely Surya Bhani. Apart from other old contradictions, Madam Learned, the tribunal has discussed everything. Elaborately taking all these things, Madam. Only I'm pointing out 2, 3 things. Which is hearing, Madam. And every step, the stance is different. First of all, the mother was different. Then in the cross-examination, the stand is that the Aymanakatu is just unmother step. Now, if this kind of stand is taken in different stages, This evidence cannot be taken to confidence. Honorable Apex Court also said, long big matter. One of the judgment. One judgment, I'd like to, 2 lines. This is in my lord, Masood Khan case. 1974 AIR SC 28. 1974 AIR SC 28 and 19 same another same. Here in the pair of
Name,
Masood Khan, man.
M.A.
MASUD Masood Khan. It's a Colville's decision. Also reported in 1974 3 SCC 469. There it was case of Bangladesh, Pakistani national who was saying left to Pakistan, then came back. There was contradiction. Only one line I'd like to. While therefore it is established that the petitioner did not go to Pakistan in 1948, it cannot be said that it has been established that the petitioner went to Pakistan only in 1951. When he went to Pakistan is a matter of peculiarly within the knowledge, and he has to produce no evidence in support of that statement. Considering the frequent sales of ground, the changing of grounds, considering the frequent sales of grounds, which the petitioner is resorted to, a mere statement from him cannot be accepted as true. Here is also matter. The statement he's changing, this ground is changing, her ground is changing time and again in each case. So her statement cannot be accepted for the purpose of citizenship. It cannot be accepted as true. So her other part of the statement cannot be accepted as true. For that reason, this is also valid in case of citizenship. And it is one of I have already said that in WS he has not written all these things. All are there. And what is there in the WS he has to put. That is in the settled position of law. There is no issue. Only my learned focus will be other aspect my lord, the Honorable Tribunal has dealt with. Your Lordship, I see my lord, the Tribunal has in fact did very well and explained everything, taken everything. It's only one point my lord, that with regard to the matter and your report that is blank, what should we do? That is also settled by this union. Sure, Lordship, may kindly take this judgment, recent judgment. This is WPC 245 2019. 245 2019.
Who?
245, madam. 245 of 2019. Shukurzan Nessa. SSU AUR Shukurzan Nessa. There the issue was exactly the same which my learned friend was his blessing with. There the para 12, what the question was, on the basis of the submissions made by the learned counsel for the petitioner, the following points of determination are up for decision in the case. Number 1, whether the reference, which is based on LBO report, as forwarded by DRO, wherein certain paragraphs, columns were left unfilled, details the proceeding before the foreigners team. Exactly what my learned friend is saying. Whether the impugned opinion is otherwise liable to interfere, that is which will take. There my submission was, madam, it is recorded here. Madam, what is the in case of defuder cases, where madam, the reference is coming from defuder, the process was madam, notified by the Election Commission of India in 1997. How this cases has to be madam, assessed. It's a intensive revision was done in 1997. The notification madam, clearly says if during the intensive revision, if DRO found doubtful a person to be doubtful, he has to send a matter, verify the matter through a local verification officer. That is called LVO. LVO is not a person from election office. He's an independent person. It's not he's a government service, but he's an independent person, not from the election office. He's not well related to election office. Now, the LVO has to make a verification, local verification. And he has to give a report to the ERO. For what? To satisfy the ERO that the person against whom there is a doubt is created, his name can be continued in the voter list of 1997. It is the LVO's report which has to be satisfied, which is to be satisfactory to the ERO. If LVO cannot submit a satisfactory report, then ERO has no option but to send the matter to the foreigners to come for a reference. That means if LVO report is blank, it is the bounden duty of the ERO to send the matters to the foreigners to come for determination. If the report is satisfactory to the ERO, then the ERO will allow the name of the person to be continued in the voter list of 1997. So if the LVO report is blank, it is against the petitioner only. LVO, what he has to do? Whether I'm not saying of the record, I can say whether their allegation is that the LVO does not visit to the house of the petitioner, they do not do. That's a different issue. Whether they have not challenged that is a different aspect, that we cannot see whether he visited or not. But if LVO does not provide any satisfactory report to the ERO, what ERO will do? He will send a matter to the foreigners to me. That is exactly this honorable court has settled this case matter also. That is settled by this one. And another aspect matter, these cases are coming, these reports, these LVO reports, these inquiries were met during 1997-98. Now, the Foreigners Tribunal, they got jurisdiction of these cases only after 2005. By virtue of the judgment of the Honorable Apex Court itself. Now, my question is, can we raise objection? Because the Honorable Supreme Court has directed all the matters pending before the foreigners, IMDT tribunals and reference, those has to be sent to the foreigners tribunal. Supreme Court has not given any qualification that only this kind of cases has to be sent. Only this has to be sent. Whatever pending in the IMDT tribunal, everything has to be sent. Now, by virtue of that, this opinion, this reference was sent to the foreigners tribunal after the judgment of the Honorable Apex Court. If my learned friend, or the petitioner, is not satisfied with the sending of the particular case to the foreigners tribunal, they could have silenced the Sarbananda Sonal. If Sarbananda Sonal is not silenced, this opinion, the tribunal cannot have the jurisdiction to return return this matter to the reference authority. No, I cannot decide this as the reference is bad. Tribunal has no right to do that, because they have got the jurisdiction only from the direction of the Supreme Court in Sarbananda Sonal.
Sarbananda 1.
Sarbananda 1. So in that case, my lord, that case also, this is also taken care of in this case, my lord. In that case also, those references which were made prior to 2005, that means passing of the
Under the IMDT Act.
Yes, IMDT. So to say, those cannot be interfered by the Honorable Court or by the tribunal, because it is by virtue of the judgment of the Sarbananda Sonal only the jurisdiction got by the tribunal got the jurisdiction. Otherwise, tribunal would not have. And there is no qualification that only this kind of cases has to be settled. So this judgment, my lord, in this judgment, all these things has been discussed and this is settled. So I don't think, my lord, my learned friend submission in that case have any legal due. And otherwise, facts may not, in facts, I have already submitted, only my submission is that I will again submit in being certiorari jurisdiction, we may not interfere in findings of the tribunal. If it is-
Your colleague is also praying for a remand to allow her to adduce further evidence.
That cannot be done, my lord. That cannot be done because to satisfy the your lordship, that she has to satisfy that why it has to be remanded. Why it has to be remanded? The remand is not a my lord ordinary course where if my lord prayer is met, it has to be sent.
Lordship, may I answer to my learned
Yes,
friend?
yes, make a short, we'll rise after this matter. My brother has a single bench.
Lordship, one query is that I need to go through that judgment which my friend has relied upon, because the Anjana Biswas judgment which I have relied upon, that 2023 2 GLT 1102, that is very clear. So I just want to go through this and then I would like to make my submission if Lordship's allowed.
No, there's no, thing,
And
nothing in installment.
then with regard-
We'll consider your citation, we'll consider his citation. We'll try to have the correct.
Yes, Lordship. And Lordship, my learned friend also said that WS, even in the Foreigners Tribunal order, so it's only making a representation.
That is no more intricate.
Yes, and-
Settled position of law.
May I
They-
complete? Because my friend has submitted and thereafter I sought my permission of Lordships to answer back to my learned friend.
Yes, yes.
Yes, and procedure for disposal of question. The tribunal shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged.
Order three, you're.
Yes, Lordship. And it's that making a representation and producing evidence. It's not like the WS as per which is also being clearly, I would like to rely upon Hyder Ali paragraph 26, Lordship. It's not as per WS, as per CPC. It's clearly states only representation. There might be some not stated there, but it's stated in the cross or in the evidence, because one name which is mistake in the WS Lordship, in the evidence as well as in the cross, it's correct, Lordship. And again, my humble submission before Lordship, once and again, I will say that a genuine citizen should not be, since her case was not properly been established before the learned tribunal. So if one chance is given to her, remand back the matter. And then that is also, I prayed before this on prayer number, Lordship, that also I state prayer number, I think, for
Regarding?
remand back, Lordship. My one and only prayer is remand back, Lordship. Because, and her, because of that only she will be saved. Otherwise, it's difficult, Lordship. I can understand.
Okay.
Paragraph, page 30, Lordship, prayer number 4. And anyway, whatever documents I have placed before, if I prove also, stream foreigner. Whatever documents I have exhibited before, and this is the reason I humbly pray if I am allowed to remand back with filing additional WS and evidence, so that I can bring in more documents. One humble submission also is that, Lordship, there is no appellate provision to that. So certiorari jurisdiction, I can understand, is limited, but it's a citizenship right, Lordship. Otherwise, it is difficult, Lordship. Otherwise, this person will become stateless.
This legislature's intention, my lord, by which
We have to balance. The objective of the legislation cannot be made futile.
yes,
A mechanism has been laid down.
No, my lord,
Whether
this-
the mechanism has been properly exercised, we'll see to that.
only point, my lord, which
We'll
reminds
see to- If it is not properly exercised, then matter of interference will be there.
remand, my lord, the matter pending since 1997, reference of 1997. Now again remanding, that aspect also
Lordship, if if my learned friend has submitted that, then I also have a counter submission to that, is that if yes, reference was made way back in the year 9, even the date is not there, Lordship. I have placed before, date is not there when inquiry was even made. So casual manner it has been done. But still, if I say 97, 97 the reference is being made. But then it took such a long time to issue notice, because if the law it says that then within 10 days, reference is made within 10 days, notice has to be, yes, Lordship.
Or is that within 10 days from notice?
No, notice has to,
Law said it 10 days from notice, not notice has to be sent within.
so no, then let me complete that.
Three. Rule 3 itself. Within 10 days from notice. Reply has to be given within 10 days from notice.
Main grounds, reasonable opportunity to represent evidence. 10 days from the notice, but
Not-
they also have to, service of notice. Let me just, I can paste. But they took such a long time to issue notice. If I say 97, then in 2090, when she has received the notice, 1 second, she has notice was issued. Notice was issued to her. Notice was 19, Lordship, 28/3/19. 19 notice, 97, then they took so many years to issue notice to me. 28/3/19 notice was issued to the proceeding, Lordship. So if that is, so if it's remanded back, Lordship, she
No,
can.
how does it make a difference? What prejudice have you suffered?
No, I have suffered is I'm devoted. Definitely I have
No, no,
suffered
that's a
because.
different.
Yes, Lordship.
That's a different.
Yes,
text.
Lordship. Yes, Lordship.
But delay in, has it got any prejudice in defending your case?
No, one, my learned friend has submitted that if it's again remanded back, then it's 97 reference he had stated. So
No, no, we have-
notice was issued. So counter to my learned friend's submission, I made this submission, Lordship. So my humble prayer is to remand back,
Okay.
Lordship.
Okay, rest, we'll not, because my brother has a single bench, we'll rise. If there is any urgent matters, we'll fix a date. Mr. Dubey, anything?
Item 11, Lord.
What is the matter about?
Lord, it's a review
Review,
petition,
right.
Lord.
Review?
Yes.
Or by which bench?
Lord, in fact, this matter has been assigned to your Lordship's bench, my Lord, special bench.
This bench?
Yes.
By review against judgment of?
Judgment on the Chief Justice, my Lords.
Let us see.
Item.
It may not be before this bench. This bench is a very temporary bench.
I understand, Lord.
Before-
Earlier, my Lord, it was before Justice M.R. Pathak, my Lord. That matter was assigned before that bench. It's a surfacey matter, my Lord, not foreign travel.
It's not before this assigned to this bench. Not assigned.
But there is a note which says that it should come before the special bench.
Special bench should be there
Perhaps,
next week.
otherwise, that's why.
Next week, special bench should be there.
No.
Normal special bench to this. This is a extraordinary special bench for 4 days.
Only thing my friend has.
It'll be on Monday. Monday.
Monday.
Just not defined.
15th.
What was the issue? Review
Yes.
for what?
Lord, review of the judgment.
Not a dismissal, we can have it today.
Lord, I have to cross one more hurdle, Lord. We had filed an SLP that has also been dismissed.
Your SLP has been dismissed.
Yes, yes.
Did you take leave?
No, leave was not granted. That's why I'm.
Withdrawn on dismissal on withdraw.
No, dismissal,
On merits.
not on merits, Lord. I address you, Lord. But leave was not granted. Therefore, I have a right to review, Lord. That option is.
Very recently, we have not only dismissed the review, we have also imposed cost of 50,000.
Lord, I'll take that chance, Lord.
Only 50,000.
The stakes are a
It might
little
be
higher
more.
than that, Lord. So
It might be more.
I'll try to persuade your Lordship on
Last
that.
week only. Not very far. We remember. Okay.